I don't have any access to Frank Murphy's information.
Okay, do you have a number for them over there?
Let's see what I have.
Who is that? Who?
I thought I had it, ma'am, because he hasn't been to court in probably about 3 months and kept pushing it back,
Yeah.
you know?
I'm not sure, sir. All I have is a number for the prosecutor's office, so I don't know
Okay,
if you
can you give me that? Can you give me that, ma'am?
Okay, sir. 224
Two,
57
hold on, 224 57
77.
577. Hold it, 224 57.
77.
Okay, thank you, ma'am. Have a good morning. Thank you.
Yeah,
All right.
you too.
All right.
I don't think we have any custody exams today. We have a lot of exams, but it looks like they're.
Hey, Tammy, this is Susan Dunn. I'm back on Mr. Adams. We wanted to go in front of the judge on a quick bond issue. I know we had already set this for December 16th, but when I talked to him, we wanted to ask the judge about his bond.
That's fine. Is the prosecutor still on though? Because we'll have to wait and see what prosecutor. I think that's a PAT2 case and we don't have a PAT2. Do you want to?
Yeah, I'm trying to figure out who's supposed to be here.
Yeah.
I think that was Mr. Cook was covering yesterday or the day before.
Oh, is that who was covering for him? Marvin Cook.
Marvin Cook, yeah.
Yeah. Oh, okay. Yeah, I've got it here. Well, I'll see if I can, hopefully we can find a prosecutor to stand in for the PAT2 unit. Okay?
Yeah, thanks. It's not that complicated.
Yeah,
So
I got
hopefully.
What you got? Oh, okay. Yeah, I had him out, so I don't know. Sometimes they're locked up on other cases. 10-10-92.
Thank you.
I don't even have anything to call at the moment. I need the jail.
Do you guys happen to remember Mr. Cook's first name?
Marvin.
Marvin?
It's Marvin. I may have his, cell. He used to be a prosecutor over here.
Good evening. Yo. Yeah.
Good morning, everyone.
Yeah.
I just want to take a moment to
They all get changed.
welcome you to Zoom Court. Those that are new and those that are old to Zoom Court, please be mindful of a few expectations that I have. Number one, I want everyone to keep their microphones muted. Microphones muted. If you're not familiar with how to do that, just take a moment, familiarize yourself with your device. There's a little microphone, you just tap on it. And then you can tap back on it when it's necessary for you to talk. When your case is called, if you're the defendant, or even if you're counsel, I need your video rolling. So Again, familiarize yourself with your device to the extent that you know how to do that. It's just a little camera. You put, very simple, very straightforward. You just tap on it and your video will begin rolling. Likewise, I want you to be mindful that Zoom court is tantamount to being in a courtroom. So my expectation is that you would wear clothes. Clothes. I need you to have clothes on and to be properly clothed. That seems fairly obvious, but inevitably every day it seems to be something that people don't assume that they need. Secondly, please refrain from the use of any profanity. And just simply conduct yourself as you would if you were inside of an actual courtroom. That would be great. If there's any special motions that are going to be requested, please make sure that you are having a conversation with opposing counsel prior to said motion, so there's no element of surprise that would prompt us to have to pause the proceedings. If you are defense counsel, please allow the prosecutor, when the case is called, please allow them to put their appearance on first. If you don't hear the prosecutor put their appearance on, please do not proceed to put your appearance on and introduce your client, because we cannot proceed in a matter if both prosecution and defense are not there. We will have to pass on the matter, and it's nothing personal. It's just we need both prosecution and defense on any given matter. If you're defense counsel and you're not sure if your client is present, please make the necessary inquiries. Do not assume that this court knows if your client is present in Zoom gallery or otherwise. I don't know what your client looks like, so I don't know if they're in or if they're out. You have way more information than I do, so please let the court know if they're here, and if they are, I need them to state their own name. If they are not present in Zoom gallery, then I need you to let me know if you're requesting to waive their presence. As long as you're in good communication with them, then I'm usually pretty comfortable with doing that. If you are going to be handling any personal business, this is for defendants and witnesses and attorneys alike, please make sure that you turn your video off. Personal business would include going to the bathroom or anything, eating a meal or sleeping. Please make sure you turn your video off. As soon as we have something ready to call, we will start calling cases. Apparently, we're in a little bit of a holding pattern, so please be patient with us. Thank you.
Good morning, Judge. This is APA Cooper. I noticed that some witnesses on the Iverson matter are on the Zoom meeting. If you could instruct them to go to YouTube, that would be useful.
It's just Iverson is scheduled for a probable cause. He's in custody, so he's not available.
Who is that was speaking, please?
APA Cooper.
Oh, okay. Well,
Yeah, I just noticed the last name is showing up on a number of screens. So I want to make sure that if those are witnesses, they shouldn't be here.
Is it a Zoom exam?
No, today is just a PCC, Judge.
Okay. Well, they must have gotten the number from someone. If it's a conference, there usually is not a sequestration. Certainly, if they're your witnesses, you can state to them what you just said. I don't know who exactly you're talking about, but I would state as a side note, if there's anyone with a device that's logged on that just simply says iPhone or doesn't indicate what your actual name is, if you could rename your device to your name, that would help us to know who's here. And it's a capability that you have. If you just go to like the upper, I think, right-hand corner, press on the dots, and it will give you the option to rename. Again, Madam Prosecutor, if you don't want those witnesses to be present inside the Zoom gallery, you can call them or.
I'm referring to any witnesses who are here on the Iverson matter. You can watch this proceeding on YouTube, and that would be the preferential way of doing this. Just watch on YouTube. Thank you.
That's interesting. I've just never heard a request like that, but I don't have any particular, Madam Prosecutor, any particular restriction in that regard, but certainly if you've been in communication with your witnesses and would rather them watch us one way as to another way, that I'm fine with that. We're going to mute the microphones until we've got something ready. Hi, Mr. DiMaggio.
Hello, Judge.
How are you?
Good. Better than I was 2 weeks ago.
Oh, fantastic. What, you're okay now?
Yeah, I had a hamstring injury, but it's getting better.
Oh, boy. Well, I'm glad to hear that.
Yeah. Good to see you, though.
Good to see you too. I don't think I've seen you. Mr. DiMaggio, I don't think I've seen you in person since the pandemic started.
I don't think so.
Yeah.
I saw Tammy on the street once.
Which street was that? I don't know. That doesn't sound very good, Mr. DiMaggio. Interesting.
Yeah.
Okay. So listen, what I'm gonna ask, and I'm gonna ask this one more time. And she thinks I'm gonna say something interesting, but I'm really not. I'm really not. What I am going to ask is that if you are in the Zoom gallery and you have a device that is labeled something other than your name, that could be iPhone or TCW, Justice for AI, I need you to rename your device such that your name is present. Now, for those that cannot do that, I have a special place for you. And it's called the waiting room. As soon as you're able to rename your device, I'll bring you back in. But anybody that does not have their name, first and last name, not initials, not a nickname, you're going to be in the waiting room. Necessary for us to know who's here. Thank you so much. I appreciate it. That would include individuals that just have one initial, like a K. Oh, thank you, Portia Smith, for renaming your device. There's a K. I'm going to put you in a waiting room until you can rename your device.
Oh,
Much appreciated. Thank you, Mr. Curtis, for renaming your device.
okay, I remember this now. This is tattoos. It looks like they added, or maybe added or something happened, but there's now a count of, stolen property, receiving and concealing 20,000 or more.
Oh, okay, so that's why that's, was that amended?
Thank you, Mr. Alston, for renaming your device.
Because that's not on the complaint anywhere that we have in this file.
Yeah, I don't know. It doesn't say amended on it, and it shows that it was signed, or that we signed it
Yeah, so we had this yesterday with the case.
on 7/12.
Please mute your microphones. Please mute your microphones. Thank you.
This is one. Do I have the parties on Adams and Mitchell, Miss Dunn, Mr. Humphries?
Tammy, we set a new date for December 16th for an exam on that case, but I don't think Mr. Humphries is going to come back, but I was just going to address bond for Mr. Adams.
Okay, so I'll just read just your case then. Calling parties on Adams, case number 2159564, the people of the state of Michigan versus Keontae Adams. The defendant is charged with count 1 and 2, police officer, 3rd-degree vehicle code. Count 3 and 4, police officer fleeing 3rd-degree vehicle code. This matter is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Brittany Bailey on behalf of the people, P84009.
Good morning, Your Honor. This is Susan Dunn. My P number is 58696. I represent Keontae Adams.
Okay, and Mr. Adams, is he present?
Yes.
Could you please state your name?
Keontae Adams.
Thank you. Okay, Ms. Dunn?
Thank you, Judge. Judge, Mr. Adams is out on a tether, which, you know, he appreciates not being in jail, but the tether is just causing him issues. He lost his previous job and he's looking for new employment, which should not be an issue, you know, with the labor shortage. He also is trying to go to school to be an electrical technician at Dorsey, and that starts August 16th. So the tether has just been really hard for him to function. He lives with his girlfriend, and he's very young. So, you know, I give him props. He's out on his own, trying to pay his bills. We're asking that the tether be removed so that he can get back on his feet. He did turn himself in, Judge. He's been in constant contact with me. I don't think he's a flight risk. He only has one prior CCW, which he's on probation for now. And as far as I can tell, he's compliant.
Okay, let me first ask before the prosecutor responds. What is the future date? I think you got the date off the record. What was that date?
December,
Pardon?
December 16th.
For an in-person exam?
Yes, ma'am.
All right. Well, Ms. Dunn, let me tell you, I just have to, while I understand your argument, I have to look at the four corners of the file. And when you say he's not a flight risk, he's charged with 3 counts of fleeing and eluding.
I do understand that, Judge.
3 counts. Wait, I'm sorry. He's charged with 4 counts. He's charged with 4 counts. So, now wait a second. This sure is interesting. He's charged with 4 counts of fleeing and eluding from one single occasion, 4 different locations. And so when you say he's not a flight risk, can you please elaborate on that?
Well, Judge, like I said, he turned himself in as soon as he found out he had a warrant. As far as I can tell, he's been compliant with probation. I don't have the advantage of having discovery on the file. I do know he's charged with fleeing and eluding, but that's all I know. And that's why we put it out for exam, because we didn't get discovery yet. I know the prosecutor this morning has promised to get it to us, and I may even have it already on my email. But, you know, just because of the lengthy exam date, that's going to be another 4 months of
Notwithstanding the prosecutor's response, I'm going to deny that motion to remove the tether. But what I will do is I'll give you an exam date in September.
Okay.
However, an exam date in September for a non-custodial, you know what that may look like, right?
Yes, I know. I was there for 3 hours yesterday doing an exam.
Because our priority is in custody. However, look at today. It's very unusual that we're not already running around crazy. They're apparently in custody exam today. So had you been here today, we would roll right into it. So why don't you select a date?
Well, Judge, I have another suggestion. Sorry to interrupt, but is there any way that you could put in the file that the tether company can allow him to go to work and school while he's on the tether, so he's not just homebound? That's all I would ask. Like, even put some hours in there for him.
Well, Your Honor, if I might be heard, he already has an exception for work. He's not precluded from going to work. That was established on July 18th. GPS tether can go to work only.
Okay, he didn't know that. I don't believe he was aware of that, but that helps. And maybe if we could put something for school in there, I'd like to see him get some training. He does have a diploma.
Is he enrolled in school?
Mr. Adams, are you formally enrolled, or are you just planning on going to Dorsey?
I'm trying to go, but this tether is not letting me. Like, they say I could go to work, but then I lost my job because of this.
That's not
I can't get another job. It's like I can't go find another job. Like, it says I can go to work, but I can't find another job.
Would you like a breakout room with him? Because if there is already a caveat that allows him to go to work, I don't know why he would have lost his job, number one. Number two, I'm still not understanding whether or not he is enrolled in school or just wanting an option to go to school.
I'm enrolled. But I still have paperwork to do with them. I'm
Okay.
accepted and enrolled.
What about a caveat just saying that he's allowed to seek employment as well as go to work?
Your Honor, I'm fine with having it read that he can search for work, that he can go to school if he provides the tether unit with a list of his scheduled class times, and work's already there. I certainly don't wish to prevent Mr. Adams seeking employment. But I just would ask some extra keeping to show the tether unit. I have an interview on this date at this place. I have class these days at this time.
Ms. Dunn, what I need you to do is to have a conversation with him a little bit more in depth and provide a proposed order that would be very specific with regards to any exceptions that he's got on this GPS tether. And provided it makes sense and I approve it as to form, as well as the prosecution doesn't have any issues, then I will sign off on that. But that still begs the question, did you want to hasten the exam date or no?
Judge, if we get these tether modifications, I'll just keep the exam date. He does have a co-defendant, James Humphreys is on there, so I think it'd be complicated to move that up. I'd rather just keep the exam date. If we could get these tether provisions, like just allowing him to seek work if he provides info and go to school if he provides info, I think that'll do it.
Wow. Yeah, it's the discovery is very interesting on this. I think that you might not have said that he is not a flight risk had you read through this, where they attempted 4 separate stops and speeds had exceeded 100 miles per hour. So involving both DPD and troopers. I'm not comfortable with removing the tether. You can provide a proposed order to the effect that we just indicated, and so long as it seems to make sense to me, I will execute it.
Thank you. I'll email that to Ms. Jones.
Thank you so much.
Thank you, Judge. Thank you, Tammy.
And Miss Bailey.
And Miss Bailey. Yes, and Miss Bailey.
Who's Miss Bailey? Oh, the prosecutor.
Prosecutor.
Thank you.
Today, anyway.
Thank you, Judge.
You're welcome. Thank you.
Ms. Farkas, are you back on low or do you have other matters this morning?
Just on low.
Okay. Can I call that?
Yes, Tammy.
What time is that exam date for Adams?
It's on the front of the spot.
Thank you.
Calling parties on low, case number 2061413, the people of the state of Michigan versus Joseph Lowe. The defendant is charged with count 1, weapons carrying concealed, habitual offender, third offense notice. Judge, this is back as sort of a status conference this morning.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Mr. Lowe. Your Honor, you may recall from yesterday, we had an in-person exam scheduled on this case. Mr. Lowe was not present. I had told the court how Mr. Lowe's brother had informed me that he was in the hospital. Unfortunately, Judge, I have not been able to secure any documentation to confirm that is actually the case. And so I'll just leave it to the court what the court would like to do with the matter.
Okay. So you have not heard anything from either the defendant or his brother?
I talked to his brother. I was able to, I have, the phone number that I have for my client is not in service anymore. So I did talk to his brother yesterday. He informed me that his brother had surgery, but he thought that he may have been released from the hospital. But I have not been able to confirm that through any other source of information.
Okay, is there a motion?
Your Honor, at this time, the people would motion for KPS.
KPS was going to issue. This matter was set for yesterday, and this court held off on taking any action because of the representations that were made by Ms. Farkas. But the idea was to put this over so that there could be some confirmation about hospitalization. Certainly, I do find that to be good cause as to why someone wouldn't be able to appear. But given the fact that there's been no information and no communication, as indicated by Madam Defense, that leaves the court in a quandary. And I'm going to grant that motion for KPS in the event that you do speak with your client. Please just zoom on in and we'll address the KPS. But the KPS is going to enter probably around 2 o'clock is when Madam Clerk generally enters those. So the KPS is going to enter, previous bond is going to be revoked. New bond is going to be set at $5,000 cash or surety.
Thank you, Judge.
Thank you.
Yeah, case is scheduled for 9. I'm not sure if anyone's out there or not.
I know that I am prepared on Hayden Johnson.
Okay.
I don't know about Bowen.
Is there, is Mr. Kinney out there or anyone out
Mr. Kenny's
there?
here, his client is not.
Okay, so as soon as they get here, you can, whoever gets here first, Bowen or Johnson.
Okay, and Ms. Jefferson's missing on both. One is here.
Did we get a new date for Mr. DiMaggio's client?
He's in lockup in custody, so no. The jail hasn't come on yet.
Gotcha.
Iverson or Robertson. I'm just waiting on attorneys. So there's 2 9 o'clock time here, and we should have people showing up for the 9:30s. Is Mr. Clements out there on his?
Oh, this is, yeah.
It goes in, yeah.
Really?
Only parties on Leggett, case number 2056250, the people of the state of Michigan versus Ronald Maurice Leggett. The defendant is charged with count 1, 2, and 3, check non-sufficient funds, $500 or more. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning.
Good morning, may it please this most honorable court. Rena Mitchell appearing on behalf of Mr. Leggett. Your Honor, is he in the waiting room?
No, I don't think so.
He didn't check in with me.
I don't have anyone in the waiting room right now.
Your Honor, I'm gonna ask for another PCC date. I believe it's gonna be a waiver of the preliminary examination, but I need him here to actually waive the preliminary exam, Your Honor.
Okay, so do you know, I'm gonna bring this one person in to see if this is your client. This came in with a device titled Zoom user.
Okay.
I was like, that and not me out.
Zoom user, please state your name. Zoom user, please state your name. If you do not state your name, I'm gonna put you in a waiting room.
Latoya Jackson. I'm sorry.
That's okay. Hold on, Ms. Mitchell. iPhone user, please state your name.
They're still connecting, Judge.
iPhone user, please state your name.
DeMar Hall.
Thank you. Oh, Mr. Hall, if you could rename your device to your actual name, that'd be great.
Okay, I went to my meeting setting and it's not letting me rename
Mr. Hall.
that you said.
Thank you, hold on. iPhone user. You're going to be put in a waiting room if you do not identify who you are and rename your device. Putting you in a waiting room.
I tried to.
Mr. Hall, I was not actually referring to you, but thank you so much.
Okay.
Okay, so your client apparently is not here. Are you requesting to waive their presence?
Yes, Your Honor.
And he's out on bond?
Yes, Your Honor.
So ordered. And what is your pleasure?
Your Honor, I would like another PCC date.
Okay, a couple weeks off, a week off? What's your
A
pleasure?
couple weeks.
Okay, today's 4th, so what about the 18th, August 18th?
That works for me, Your Honor.
All right, new PCC, August 18th at 8:30 via Zoom. Again, if his intention is to waive the examination, as you know, he does need to be present and with a device that can function properly with audio and video.
Thanks, Judge.
Thank you.
Have a great day.
Too.
Ms. Mitchell?
Yes, you were gonna speak on our other cases. I was trying to get my other client to Zoom in today. So I'll just email you to see if we can Zoom in later to handle both of those matters.
Are you talking about Cooper, Caesar Cooper from yesterday?
Caesar Cooper and Andre Whitfield.
Okay, what's going on with Andre Whitfield?
It's a waiver. He has another case over at Frank Murphy already, and I was trying to get both of the cases to catch up. We have a prelim in front of the judge in November, and so I wanted to waive that, but you needed to bring the file up.
Okay, so can you just email that information to me? Do you want to do that today or you want to do that another day?
I would like to do it today if my client answers the phone, but I'll just email you so I won't hold the docket up.
Okay, thank you.
All right, have a great day.
Calling party on Johnson. Case number 2061920. The people of the state of Michigan versus Braden Van Johnson. The defendant is charged with count 2, police officer assaulting, resisting, obstructing. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Judge Robert Kenny, appearing on behalf of Mr. Johnson, 35 Lake 42. Mr. Johnson has indicated to me that he understands what a preliminary examination is, wishes to waive his right to one right now.
Any objection to the proposed waiver?
No, Your Honor.
And could you put your name on the record, sir?
Braden Johnson.
Thank you. Sir, do you understand the allegations against you?
Yes, Your Honor.
Do you understand that you do have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur, prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes, ma'am.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process, sir?
Yes, ma'am.
So the representation has been made by your attorney that you wish to waive, to give up your right to preliminary examination. Is that true?
Yes, ma'am.
And do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes, ma'am.
And is that still how you wish to proceed?
Yes, ma'am.
Are you doing so voluntarily?
Yes, ma'am.
Thank you. I do have an examination waiver form that I'm handing up to Madam Clerk. I need your signature, counsel, as well as your client's. It basically reiterates what I said verbally. I do find your waiver to be knowingly and voluntarily given. Matter will be bound over to the circuit court for further proceedings with an AOI date of August 25th at 9 a.m., August 25th.
Thank you, Judge.
Yeah.
Thank you, Your Honor.
You're welcome. Is the cookie up today?
I think that's already closed out.
Oh.
Calling parties on hold. Case number 2159523, the people of the state of Michigan versus Damar Ho. The defendant is charged with 1, domestic violence, 3rd offense, no. Count 2, assault with a dangerous weapon, felonious assault. Count 3, weapons, felony firearm, habitual offender, 2nd offense notice. This matter is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Your Honor. Brian Gagnick with the Neighborhood Defender Services, P64220.
Thank you. And your client?
Damar Hall.
Thank you. Okay, today being a PCC, what's your pleasure, counsel?
Your Honor, I have not received discovery yet. The phone number I had for Mr. Hull was not accurate, but I'm going to explain it in the same way I'm explaining to the court. I would otherwise be asking for the discovery and an in-person examination date if that's what the court is setting at this stage.
Yes, I would be willing to do that, even if you don't have discovery in your hands right now. The exam date would be set far enough out that you would be able to procure that discovery, certainly within the time frame allotted. Mr. Bloomers, let me ask you, are there any concerns regarding bond that might affect the timing of the exam?
There are no concerns from the people, Judge. I believe the defendant is on $150,000 personal bond with a GPS tether and house arrest.
Mr. Gagnick, any concerns you have with bond?
Is the court in any position to remove the tether? My issue, of course, is I don't have discovery. So I'm making a blind argument, but I always ask.
Yeah, no, I'm not comfortable with removing the tether because there's nothing before me in the file or nothing that I've heard that would suggest that that's an action that is warranted. However, with this being an allegation of domestic violence, I am going to ask Madam Clerk to secure a date that's much closer than otherwise. So what can we come up with?
Give me a month. In October still?
October, yeah.
October 21st at 11 a.m.
October 21st. How about do you guys have the 20th available? I happen to be in your court at 11:30 on that day.
Let me see. We can do the 20th at 11.
If that's available, I would appreciate.
Okay.
I have a question too.
In-person examination is going to be October 20th at 11 a.m. The expectation is that your client, Mr. Hull, that he would be present inside of the courthouse, not on Zoom, in the courthouse, as would any witnesses that the prosecution intends on calling. Mr. Gagnon, was there something further?
No, well, I do need to get a contact info from Mr. Hull, or if he's got a pen, I'd like to give him my phone number. If he doesn't mind, he can give me his right now.
Well, I don't want to do that.
313.
Excuse me?
Okay.
I don't want to do that over YouTube. Thank you so much.
I
Do you want
understand.
a break?
I have a question too, ma'am.
Mr. Gagnon, do you want a breakout room with him?
Yes, please. Yes, please.
And then he can tell you what his possible question might be, and I don't want him to ask. Yeah.
Thank you.
Is there anyone else in the hallway that's ready to go?
Hicks, are you ready?
Hicks is ready? Okay, Judge, this is the case that Mr. Clemens filed these two motions on. So I'm gonna hand
What
this
about
to you.
Thomas, Deleon Thomas?
And his attorney.
And Bowen?
Thomas should have
Deleon
been
Thomas, Your
removed.
Honor, I believe was adjourned last
What
week.
about Bowen?
Mr. Bowen is here, I believe, but Ms. Jefferson hasn't appeared yet.
And I have witnesses on Bowen.
So I'll see if I can make a call to her and see what's going on with her. Yeah, Thomas was one of those dates that the magistrate said and then the clerk didn't take the exam data.
Okay, is Mr. Clemens making his way in, or?
He's in the hallway.
Okay.
Because we're, I don't have any, well, when Mr. Gagnon comes back out, he has one other case. But other than that, other than the jailers, all of the probable causes are done. Yeah, I don't know if there is a response. I didn't see any.
Mr. Gagnon, did you have anything further on Hull?
Your Honor, his issue is that he's been placed on house arrest. He does work from 8 to 5. It is a cash job. He's doing home improvement. Is the court in a position or the prosecution to agree to allow him out during daylight hours, 8 to 5? That's his working hours.
Mr. Boomers?
If defense can provide some proof of verified employment, then I wouldn't have an objection to that. But we're dealing with a domestic violence third offense notice and a felonious assault with a pistol, and the defendant has a domestic history with this complaining witness. He has 3 prior domestic violence convictions. I am not going to agree to just a blanket let him out during the day terms, but I guess if he can provide verified employment, I don't have a problem with him going to work.
I'll run that route, Your Honor. I appreciate it.
Hold on. What I'm willing to do then, in lieu of granting your request for that. We're gonna bring that exam date close. Are you available on the August 31st?
Let me double check, Your Honor. One moment, please.
Or August 30th?
I can make either date work, Your Honor.
Which is less.
Let's do 11.
Which date?
August 30th and 11.
August 30th at 11.
August 30th at 11.
The Monday,
accept.
August. Please, Mr. Hull, please note that change from October 20th to August 30th at 11 a.m. inside of the courthouse. The motion to alter the tether restrictions is denied. But I will bring that exam date much closer. We will see you on August 30th. Please make sure that you refrain from any level of contact with the complaining witness, Mr. Hull. Is Mr. Hull here?
You know what? I'm not sure if he came back in the room. I can inform him of everything the court just said, if that is okay. I understand that you are placing an order down. I have one more matter in your court. Why don't I log off? Well, no, he just reappeared, Your Honor. Excuse me.
You brought him back. Mr. Hull, the motion to provide you with a lift of the restriction of the GPS tether is denied. However, I'm bringing your exam date much closer. Your exam date is going to be August 30th as opposed to October 20th. It's going to be August 30th at 11 a.m. inside of the courthouse. In the meantime, there is to be no contact. You are to continue that. No contact with the complaining witness, not directly or indirectly, no form of social media outreach, telephone, texting, chat, letter. Even if the complaining witness comes to your doorstep, you are not permitted to engage with her. You understand? Okay, and the record reflects he's nodding his head that he understands, leading me to believe that that's an affirmative. And please note that if there's any violation of that no contact, the consequences that your bond could be revoked. So it's very serious. We will see you on August 30th at 11 a.m. in person.
Thank you, Your Honor.
Thank you.
I'll call your case next, your other case next, but Judge, can we see who's in Division 2?
Division 2, what's your name, sir?
This is Keith Robertson, Your Honor.
Thank you.
Mr. DiMaggio, did you need a breakout room with him?
Oh, yes, that would be good.
Okay.
Calling parties on Spencer, case number 2159525. The people of the state of Michigan versus Galeon Spencer. The defendant is charged with count 1, malicious destruction of fire or police property. Habitual offender for defense notice. This is scheduled for a probable cause conference.
Thank you. Please.
Sam White on behalf of the people requesting permission to practice NCR 8.120 under the supervision of Brent Bailey.
Brian Gagnon, Neighborhood Defender Services, P64220.
Okay, thank you. Your request is granted, Madam Prosecutor.
Thank you, Your Honor.
Your client?
Your Honor, how does the court have his spelling? I did not have a working phone number, and I was searching with different spellings of his name. First name, last is standard.
The first name is Gayeelon.
I've tried that spelling, and I've had no luck identifying my client anywhere else. Is the court in a position to allow me a short period of time to try to find a better number and locate him?
Sure. You want to adjourn this for a week or?
If the court would be so inclined, please.
Sure. We'll adjourn this to August 11th. Does that work for you?
Let me double check that. August 11th. I'll make it work.
Okay. New PCC, August 11th at 8:30 via Zoom.
Was that, did you say 11:30, Your Honor?
Oh, I'm sorry, at 8:30, August 11th at 8.
Understood. I appreciate. Thank you.
You're welcome.
Thank you.
Calling Raleigh parties on Hicks, case number 2058315, the people of the state of Michigan versus Terrence Hicks. The defendant is charged with count 1, weapons carrying concealed, count 2, weapons, firearm brandishing in public. The defendant is also charged in case number 2061254, the people of the state of Michigan versus Terrence Charles Hicks. The defendant is charged with count 1, weapons carrying concealed. These matters are scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Adam Clements appearing on behalf of the defendant, P number 772337. Would you state your name for the record?
Terrence Hicks.
One more time.
Terrence Hicks.
Thank you. Okay. This is set for an examination as well as counsel had filed a motion. I don't see a response from the prosecution. Has there been any headway on that? Has there been any discussion at least, or is the prosecution aware of the motion?
I am not.
Okay, we're gonna pause. You can have that copy. I've got another copy. Is there another matter in the hallway we can call? Has Miss Jefferson arrived yet?
I zoomed in last week, actually.
Yeah.
Miss Silver's here. What is she here?
Her client is going to jail, and
Oh,
that's the case that Miss APA Cooper is on.
oh, I see. Okay. Any response from Ms. Jefferson?
No, let me see if I can send her an email too. She cleared out her voicemails. Mr. Bowen is here though, correct? Hi, Mr. Bowen. Hey, there was an he's in the hospital. He's in the hospital. Miss Bailey, do you have witnesses on Bowen?
I think so.
I'm just checking to see. She's checking.
Yes, I do.
Yeah, there are witnesses here. Okay, all right. All right, okay. All right, she's on her way.
Coffee parties on. Oh, that's not the right one. Robertson, Keith Robertson,
Ready, Your Honor.
case number 2159548. The people of the state of Michigan versus Keith Allen Robertson. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, operating license suspended, revoked, denied. Habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Andrew DiMaggio, P45619. I believe I'm in the capacity of a standby attorney, and Mr. Robertson would like to represent himself.
Mr. Robertson, please state your name.
Robertson.
Say it one more time, sir.
Keith Robertson for the defense. Good morning, Your Honor.
All right, thank you. Okay, so it is a PCC. What is your pleasure?
I would like to move forward with the preliminary exam, but I have some issues that I would like to raise for the court before the preliminary exam, Your Honor.
Okay. What are the issues? Please mute your microphone. What are the issues?
I would need the body cam and the dash cam video, and maybe the full discovery. I will also need videotape from Detroit Detention Center. It shows that I was held over 24 hours in confinement. I would like to argue the right violation at that time too. But mainly I'm asking for the police officer's body cam, dash cam, police reports, things of that nature, Your Honor.
Okay, so let me just first state this. Hold on one second.
Is he representing himself or?
Can you give me a moment, Ms. Bailey? As I put my hand up, I thought that was kind of a clear indicator, but could you just give me a moment? You certainly will have an opportunity to speak, respond in any way you deem appropriate. Mr. Robertson or Robertson? Robertson?
Yes, ma'am.
Mr. DiMaggio has indicated that he's in an advisory or a standby capacity. What does that mean? And that question is for both Mr. DiMaggio and for yourself.
I'm defending myself, and he's my standby counsel, Your Honor. He is also my standby counsel in a higher court, so we do already know what's going on with these cases, Your Honor.
Okay, so he is your attorney of record?
No.
The reason why I ask these questions is because it's really important. If he is not your attorney of record, we've got to spend some time together talking about quite a few things.
Okay, it's okay.
I need to know, because if he is your attorney of record, I'm certainly not going to go through the litany of information that we need to have on the record. But if you are representing yourself, if you're in pro per, then we need to spend some time talking right now.
Yes, I am in pro per. I am representing myself, Your Honor.
Okay, so this is what needs to be discussed. You understand, sir, that you have a right to an attorney?
Yes, ma'am.
You understand that if you could not afford one would be appointed to you? Pardon?
Yes.
You understand that if you decide to give up your right to an attorney and represent yourself, notwithstanding the tremendous amount of knowledge that I'm sure you have, without a P number, you are going to still be held to the same standard. I think you're nodding in agreement. It sounds like you've already indicated that you've been in this position with Mr. DiMaggio before, so I'm sure you've heard this speech. But this is more so for the record than it is for you then. You understand that by representing yourself, that you are going to be possibly putting yourself in a situation where you might be presented with certain pitfalls that you're not prepared for. You understand that?
Yes, ma'am.
And that I, as the judge, am not able to provide you with any level of deference because you don't have a P. You understand that?
Yes, ma'am.
And you will be held to the same standard as an attorney that is tried and true. Do you understand that?
Yes, ma'am.
With the knowledge of the court rules that are expected, and if you plan on proceeding in any manner, there's no deviation that can be permitted because you didn't know something that was necessary. Do you understand that?
Yes, ma'am. Most definitely.
You understand that you're faced with count 1, which is police officer assaulting, resisting, obstructing, which is a maximum of 2-year felony?
Yes.
And also the accompanying misdemeanor, which is a 93-day misdemeanor and or $500. You understand that?
Yes, Your Honor.
And you understand that whether it be at a pre-exam phase or at the exam, the expectation is that you would conduct yourself as an attorney would, or you might find yourself up against a brick wall. Do you understand that?
Yes, Your Honor.
And do you understand that any concerns or issues such as the ones you've raised, if it prompts you to make any requests of the court, those have to be done in writing, both to the prosecution and to the defense. Do you understand that?
Yes, Your Honor.
Okay. And with the mention that you made that Mr. DiMaggio is, I think he coined it like on a standby sort of basis, I guess I want to ask now, do you wish to confer with Mr. DiMaggio before we proceed today?
We had a breakout room, so we pretty much talked about everything that we needed to talk about, Your Honor.
Okay, so you would like for Mr. DiMaggio to remain in an advisory capacity?
Yes, Your Honor.
Okay, so interesting that you're asking for certain aspects of discovery. Not quite sure how the digital discovery can be tendered to you directly, but certainly to Mr. DiMaggio, I would imagine the digital discovery can be conveyed. Is that what you're asking?
Yes.
Okay, so just like any other case, this court certainly has an expectation that digital discovery is tendered to counsel, Mr. DiMaggio, who can in turn tender it however he deems appropriate to the defendant. And that would be the expectation in this particular case. That is, if there is digital discovery, I would imagine there probably is, given the nature of the allegation, but this is the first time this matter's up. So certainly, it may take some time to get that. Madam Prosecutor.
Your Honor, I sent the body worn camera, dash camera, were provided to me by the officer in charge to Mr. DiMaggio this morning. I will have to make additional inquiries about any video from the DDC.
Okay. So with that being said, that aspect is being addressed in the normal course of business. What would you like?
Did we get on the record that I needed the videotape from DDC, the videotape of cell 22 of DDC, the dates?
That's what Madam Prosecutor just said, that she was going to make those additional inquiries. Did you hear her say that?
Oh, no, I didn't. I'm sorry, Your Honor. No, I didn't hear that. But I would like to.
Madam Prosecutor, can you make those additional inquiries as you just said you would?
Yes, Your Honor, I'm making a note right now.
Okay.
Those are the dates of 7/13 through 7/15, July 13th through July 15th. Thank you, Your Honor.
So what do you want to do today?
Also, I would like to move forward with my preliminary exam. If I could, I would like to stay on track for the 21 days, if the court see fit, which would be next week.
We'll give you the exam on the 11th, August 11th.
Thank you.
Okay, 11th at 10 a.m. Pardon?
I just would like to put out there that I might not have the DDC video by August 11th. So I will make the request, I'll do my very best to have it, but I might not. The requests are taking a lot of time.
Okay, so that information has been placed on the record, that the prosecutor is going to make all the inquiries that are necessary to get additional digital discovery. The exam is going to be August 11th at 10 a.m.
Thank you,
Mr.
Your Honor.
DiMaggio, you're available then, right?
Oh, yes, Your Honor. At 10 a.m.?
August 11th at 10 a.m. for an in-person examination.
Yes, Your Honor. Thank you. I am available.
And Mr. DiMaggio, my expectation is that you would be in person as well and not on Zoom.
That's correct, Your Honor.
And please bear with me, Mr. Robertson, but we will have to go through the same litany of questions that I just asked you on the date of the exam as well, okay?
No problem, Your Honor. Thank you.
All right, we're all set. Thank you so much.
Thank you, Your Honor.
Oh.
Mr. DiMaggio, why is Mr. Robertson still in custody? He's on a 5,000 person with no tether.
I think there's some kind of mix-up with the tether unit because he should be out. His tether should have been on. It was issued 8 days ago, and it says 3 to 5 days, so he's way over that. I've inquired with the tether department, and they said he's on the alert list, which means that at any time it can be taken and have the tether put on. But I'm still trying to figure out what's going on with him, Your Honor, because he should be out.
Okay, so he must have a companion case, right? Because no tether was ordered here.
Right, he has a case out of Judge Green.
Oh, that's why he's in custody. Okay, thank you. Thank you. Next case. Okay,
Are we ready to go back with it? Yeah.
recalling people versus Terrence Hicks. This is 2005315, as well as 2006124. These cases were already formally called. Again, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Thank you.
May it please the court, Judge. My name is Adam Clements, P number 77233, appearing on behalf of the defendant who's also present.
Okay. And your name, sir?
Terrence Hicks.
Thank you. Okay. Take it away, as they say.
So,
Anyone?
Your Honor, as Your Honor indicated, there was a motion and brief filed a week ago. I believe requesting for an evidentiary hearing. Your Honor, given at this stage an evidentiary hearing is inappropriate, this is a preliminary examination for probable cause. Additionally, 7 business days is not a sufficient enough time for the people to have responded to this motion and brief, especially given that this date was set back in March.
Okay, so you have witnesses here, right? Pardon?
Yes, ma'am. Yes.
Okay, the issue that you're not prepared to respond to the motion or not? Tell me what the issue is.
Your Honor, I'm prepared to proceed with preliminary examination. Evidentiary hearings, it is the people's position, should be reserved for the circuit court. Today is a probable cause hearing. If it is likely that something happened or not. Additionally, this motion and brief was filed on July 26th. Today is August 4th.
Well, it's a motion to suppress, with the argument being fruit of the poisonous tree. I mean, you're saying that those arguments can't be made prior to an exam?
Your Honor, a request for an evidentiary hearing, yes. The probable cause for searching this vehicle was the complainant indicating to several different officers that the defendant had pulled out a weapon and shown it to him.
Okay, I don't want to get too far into the weeds with the details of this case, but there's 2 ways that this could be handled. If the exam was certainly set off for some time, an evidentiary hearing is not precluded at this phase of this nature, where there's an argument that there was a violation that occurred that would cause any evidence that was seized to be suppressed. I don't see anything wrong or untimely about such a motion. However, we are here, Mr. Clements, it's the exam day. You can make the same arguments that you would make in a motion, because the beauty of it is that everybody's here and in place, presumably.
I agree, Judge. The motion is, as the court knows, my firm's practice is to file the motions to almost as a courtesy to the prosecutor. I mean, I could have very well come in and just made these arguments in an exam. So we do it almost to place them on notice that This is what we're arguing.
Okay.
I mean, so this is why we filed the motion. So we could just run the exam.
Let's run the exam. But I just want to be clear that had this been filed for an exam that was set in October, the court, provided it's done in a fashion that gives people notice, the court would hear an exam, a motion, an evidentiary motion regarding a motion to suppress. That's, some motions are not appropriate for district court. This motion would have been, but we're here today. It's an exam, and presumably, again, you've got your witnesses, so those same arguments can be made and addressed at the exam level. But I just wanted to make that distinction so that everyone understands. It's not that I'm saying that an evidentiary hearing on a motion to suppress cannot be heard, but we're all here and ready for the exam, so we're going to proceed with the exam where that same arguments can be made during that exam. So can we bring in are there any preliminary matters?
None, no further preliminary matters for the people. I just ask that my officer in charge be allowed to remain in the courtroom.
And your name, sir?
Detective Stephen Boguslawski.
Could you spell your last name for Madam Court reporter?
I'm sorry, BOGUSKI.
And before we pivot just for one moment, Mr. Clements, did you have any preliminary matters?
No, I'm gonna address everything in the confines of the exam. Judge.
Okay, thank you. We're gonna pivot just for one moment and call another case that should be rather quick.
Do I have the parties on Iverson?
Ready?
Yes, good morning.
I'm
Calling
sorry, so much is happening at the same time, and I do realize now, especially with the status meetings, people going in different phases, I'm almost jealous of them, in that sense. This morning, I want to be at that phase one day, and looking back, I'm not going to, something I just dropped when I should not have done that. I do appreciate it, I really do. I want to get my mind and my situation behind me.
Muted, are you sure that's not coming from you? I just muted you, I think it was you.
Calling case number 2155331, the people of the state of Michigan versus Lartrell Iverson. The defendant is charged with count 1, homicide, murder, first degree premeditated, count 2, homicide, felony murder, count 3, robbery, armed, serious injury, count 4, assault with a dangerous weapon, felonious assault, count 5, 6, 7, and 8, weapons, felony firearm. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Judge Leslie Cooper on behalf of the people, P30857.
And good morning, Your Honor. Gabby Silver appearing on behalf of Mr. Iverson, who is appearing from Division 2.
Mr. Iverson, please state your name, sir.
Earl Iverson.
Thank you. All right, today being a PCC, Madam Defense, what's your pleasure?
Judge, I would ask the court to schedule us for an exam date. I received discovery yesterday. I haven't had a chance to look at it. It downloaded overnight. I would ask as to what witnesses the prosecutor intends to call, and then try to schedule a date.
Madam Prosecutor?
Yes, I believe, Judge, that we'll have at least 3 witnesses, 2 civilians, Eugene Iverson, who is the victim of the felonious assault and a witness to the homicide, and a lady, Kinesia Hudson, I believe her name is, and also at least 1 officer.
Can I ask who the officer is?
Could be Sergeant Thurkill.
Okay, we are going to, today's the 4th, is there any way that we can, do we have any non-custodial afternoon exams that aren't too far off?
2 out of custody cases that I can move. So August 31st at 1:30.
August 31st at 1:30, does that work?
I'm not available that day, Judge. I'm sorry. I could be available Thursday, September 2nd or Friday, September 3rd.
Can do the second, Judge. I already have an exam on the 3rd. And the 30th and the 31st.
The following week after Labor Day is also open, fairly open.
That's not open for me. Can we have the second if that's available for the court?
I'm trying to check. You guys are quicker than I can click here to check things.
The problem is our
You're the
130s
best.
our 130s are filled with homicides every day. So we're trying to find something that is non-custodial, that may not be a homicide, non-custodial, that would work. So just if you could bear with us.
Sure.
I thought they were out. So the second. She wasn't there. So the week of after 6 days out.
I could do Friday the 10th.
That would be good.
Judge, have a case scheduled in that they're out of custody. I could try to adjourn that one.
That's, you said the 10th, September 10th at 1:30?
Yes.
Okay. Madam Prosecutor, does that work for you?
That's fine, Judge.
Okay, September 10th at 1:30 will be the examination, in-person examination date. Is there anything else you'd like to address while we're on the record here?
No, Judge, can you put me in a breakout room with my client, please? I'm done on the record. If the court's done with us, I'm done. I have nothing further. And we can just leave from the breakout room.
Yes.
Thank you very much.
Thank you.
Thank you, Judge.
You're welcome. We have the other quick matters.
I think we're.
Mr. Iverson, you should have gotten an invitation to join a breakout room.
Everything else, I don't know if there's any scheduled in the hallway that would be a quick dismissals or not.
Okay, we're back on the record in the matter of People versus Karen 6. Please call your first witness and please let me know which case you're starting with.
Your Honor, the people will be starting with case ending in 8315, where the defendant is charged in count 1, weapons carrying concealed, and count 2, which is a misdemeanor, weapons, firearms brandishing in public.
Okay, your first witness.
Officer William Tatum.
changed, so I'm not sure if people are on, Zoom.
Could you please state your full name, sir, and spell your first and last name for medical reporter here?
William Tatum, WILLIAM, TATUM.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can make your way over here. This half gate will open up towards you. Watch your step. Once he's settled in, you may.
Thank you, Your Honor. Good morning. Could you please restate your name for the record?
William Tatum.
And are you currently employed with the Detroit Police Department?
Yes.
In what capacity are you employed?
Special operations.
And how long have you been employed with the Detroit Police Department?
21 years.
Were you employed in that capacity on June 30th, 2020?
Yes.
Did you work on that day?
Yes.
Were you by yourself or with a partner?
Partner.
What's your partner's name?
It'll work.
I'm sorry. Could you speak up, please?
What's your partner's name?
It'll work.
Could you please spell that for Madam Court Reporter?
ELWART.
And on that date, were you in full or modified uniform?
Modified.
And could you describe for the court what a modified uniform looks like?
We wear green cargo pants, black polo.
Is there anything identifiable on it?
Oh, yes, we have our badge and our name tag.
Were you on foot or in a scout car?
In the scout car.
Was the scout car fully marked or something else?
It's all black with Detroit police on the side.
What color is the lettering?
Gray.
Did your duties as a police officer take you to the area at or near 10,057 Pearson?
Yes.
Officer, if I could ask you to just turn whatever you have in your hands over and set it down. Is that location in the city of Detroit?
Yes.
Wayne County?
Yes.
What, if anything, is at that location?
Residence.
And why did you go there?
For our police run.
Were you driving or in the passenger seat?
I'm not sure.
Do you recall the nature of the police run?
It was a felonious assault person with a weapon.
So when you arrived at the location on Pearson, what, if anything, did you observe?
I just remember walking up and speaking with the occupants of the residence, and they told us about someone coming over there making some threats with a gun.
Objection to what they said, Judge, that would all be hearsay.
Objection sustained.
Your Honor, if
Objection sustained, you can certainly ask the officer upon speaking with the individuals, what did he do in response to what they told him? But the content of what they said is going to be, that's objection is sustained.
so after speaking with the occupants of Pearson, what, if anything, did you do?
We actually took a report based on the information that we received.
And so were you asking the questions or was your partner?
I don't recall which one of us was actually asking the question.
Okay, so I'm gonna ask that you talk about only what you did, okay? I know that you were working with a partner and that it's quite common to talk in the plural. But I would just ask you to stick to what you did, okay?
Okay.
So after taking this report, what, if anything, did you do next?
I went to a secondary location. I received information that the subjects in question from the Pearson location were at a second location.
And you recall where that second location is?
Grandview.
And who did you obtain that information from?
Another scout that was on scene. Grandview.
So after receiving this information from the other scout, what did you do next?
Went over to Grandview.
And what, if anything, happened, or what, if anything, did you observe when you arrived at the Granville
Yes.
location?
I observed the scout car and a Ford Expedition parked on the street.
And did this Ford Expedition match the information you were provided while taking the complaint?
Yes.
What happened, what if anything happened next?
I approached the vehicle to investigate the occupants of that vehicle.
How many occupants were in the vehicle?
3.
Do you recall who was driving?
I believe a female was driving. Not 100% sure.
When you arrived on scene, were the occupants of the vehicle still in the vehicle or outside of the vehicle?
Inside the vehicle.
And when you approached the vehicle, did you approach the driver's side or the passenger side? After you arrived, what, if anything, did you do next?
Made contact with the occupants, asked some questions, names, and determined that these were occupants that I had just received information about on Pearson.
And do you see any of those occupants here in the courtroom today?
I only see the male now. I don't see the 2 females, but the male.
And based on the information from the weapons run that you had done, what, if anything, did you do next?
Wait, I'm sorry. Who did you see in here?
Just the male.
And, okay.
It was 2 females and a
And
male.
where do you see him?
Over there.
What is he wearing?
Oh, gray sweatshirt with a bear or something with some ears, black ears on it.
The record will reflect identification of the defendant.
Thank you, Your Honor. So after making contact and what, if anything, did you do next?
Ordered the occupants of the vehicle out of the vehicle.
And why did you do that?
Because I had reason to believe that, once I established that these were occupants of the people described from Pearson, I had reason to believe that there was possibly a weapon in this vehicle.
And what, if anything, did you do after asking them to step out of the vehicle?
Recovered a firearm from the vehicle.
Where did you recover it from?
From the pocket on the back seat.
Driver or passenger?
I believe it was the driver's side pocket.
What, if anything, did you do next?
After recovering the weapon?
Yeah.
Made it safe, then notified my partner to place the occupants of the vehicle in custody.
Do you recall where the defendant was seated within the car?
Without looking at my report, I believe it may have been the passenger seat.
Would looking at your report refresh your recollection?
It may.
Can we stipulate that the defendant was in the front passenger seat for the record, Judge?
I didn't hear what you said.
I don't have a problem, Counselor stipulate, front passenger.
I would like to confirm what his report states and have the witness state it.
Do you have your police report with you? Would you like him to refresh his recollection with it?
I also have it here, Your Honor. I just wanted to make sure that Mr. Clements was able to.
Well, but I'm more concerned with what this gentleman has in his hand. So you can certainly show him what you're going to show him, but.
And then I'm gonna take what I'm gonna show him.
Oh, okay, so I guess you didn't need your papers. If you could just put them to the side.
Yeah, you're in front.
Permission to approach?
Yes.
So could you please review your report silently to yourself and look up at me when you're done.
It just says that, he was actually in the vehicle. I didn't state exactly where he was seated.
Okay.
Again, Judge, I'm willing to stipulate that the defendant was in the front passenger seat. Prosecution will allow.
That's up to the prosecutor. Not hearing any response, let's move on.
All right, Your Honor, I will agree to that stipulation that he was in the front passenger seat after viewing, a video that puts him there.
Okay, the stipulation is received by the court and noted that the defendant, there was a stipulation between the prosecution and defense that the defendant was seated in the front passenger seat.
So after, do you recall the evidence tag number?
Not right off the top of my head.
Would you have put it in your report?
Yes.
So I want you to, again, flip over your report, and if you see the evidence tag number on it, for the gun, I would like you to read it into the record.
636-127-1.
So after asking everyone out of the vehicle, what, if anything, did you do next?
After everyone was removed from the vehicle, that's when I recovered the firearm.
And then what?
I informed my partner that I had recovered the weapon and to place the other occupants in the handcuffs.
And after that, what, if anything, did you do?
They were all conveyed to the Detroit Detention Center.
Did you ask any of the occupants if they had a concealed pistol license?
I don't recall specifically in that instance, but that's just normal for me. I usually ask when I recover a weapon if there's anybody that has a CPL, so that I know whether or not someone's legally in possession of that weapon.
Do you recall if any of the occupants of this vehicle indicated that they did have a CPL?
No.
Did you speak with either of the female occupants?
Yes.
And did either of them indicate that the gun was theirs?
I don't recall if anybody actually claimed the weapon.
May I have a moment, Your Honor?
Sure. This client is electing not to come.
I'm just, I'm the middleman here. That's what you feel like.
Do we know, Susie?
Yeah.
You're like that, you're asking me more than.
I don't know.
No.
Miss Jefferson, she's on the way. She didn't know it was up, but her client, I guess, Mr. Mahan was asking if his client can zoom in.
Oh, yeah.
It's scheduled for in-person.
Yeah, he can zoom in, I mean, well, depends on what the status is. Madam Clerk, I mean, if his client can get here, he's supposed to be here.
I have no further questions for this witness.
You have no further questions for this witness? Is that what you said?
Yes,
Okay,
I have no further questions at this time.
cross-examination.
Officer Tatum, all three occupants of the vehicle were arrested and conveyed to the Detroit Detention Center, correct?
Yes.
Yes, thank you.
Okay, thank you so much, sir. Your next witness?
I'd ask that Officer Tatum remain under subpoena until the hearing is concluded.
Under subpoena or under sequestration? Because there was no sequestration motion.
I don't really care about the sequestration for this case, but just that he remain available in the hallway until the case is closed.
Oh, okay. Could you please stay then? Thank you so much. Your next witness?
I have no further witnesses.
Mr. Clements, do you have any witnesses?
No.
Is there a motion?
Yes, Your Honor.
Okay.
We will motion for bind over.
And usually I don't ask for this at the onset. Please make your full argument.
Well, Your Honor, we heard that on June 30th, 2020, Officer Tatum responded to a police run for a felonious assault. He spoke with the occupants that alleged a felonious assault, Your Honor. And then after communicating with another scout, he proceeded to a secondary location where he did in fact locate the defendant in the same vehicle that was conveyed to him by the complaining witnesses of the felonious assault.
Wait,
Alleged felonious assault.
Can you start over again? Because I just want to make sure I'm hearing all of your words.
Officer Tatum on July 30th,
June 30th.
I'm sorry, June 30th of 2020, had occasion and did go to 10,057 Pearson here in the city of Detroit, County of Wayne. When he arrived there, he spoke with complaining witnesses of an alleged felonious assault. These complaining witnesses provided the descriptions and information to Officer Tatum as to the type of vehicle, who it was, and the facts and circumstances surrounding that incident. Subsequent to that, Officer Tatum was informed by another scout that the defendant and his vehicle were at a secondary location, Your Honor. Upon arriving there and making contact, the Officer Tatum requested all occupants get out of the vehicle, Your Honor. We have information that Mr. Hicks was seated in the front seat of the vehicle, or in the front passenger seat of the vehicle, and that the firearm was located behind the driver's seat, Your Honor. That is well within reach of the defendant. And in conjunction with the information Officer Tatum provided about the felonious assault and the location of the weapon within the vehicle, Your Honor.
What information did he provide about the felonious assault?
Your Honor.
Other than he was on a police run.
If Your Honor would allow me to reopen the proofs, I can get more information about that.
Well, I think we can continue on. I mean, I guess I was concerned when you said the information he provided about the felonious assault, understanding that the felonious assault, the allegation of that is not part of the complaint. I understand that, but, in trying to connect the dots, I'm just listening very carefully to.
Well, Your Honor, a felonious assault was not charged in this case, that's true. However, the second count is weapons, firearm brandishing in public.
That's a misdemeanor, so I'm not.
That's a misdemeanor, Your Honor, yes, but the police run, while it was not ultimately charged as a felonious assault, the brandishing.
I'm not concerned with the brandishing.
Yes, Your Honor, I know, but that is what establishes the CCW, that is what establishes the probable cause for everything. And
But are you able to elicit that through witness testimony?
Your Honor, the hearsay, based on a report of a crime or potential crime was not allowed into the record.
Right. I sustain that objection.
So, Your Honor, I am again asking that you allow me to reopen the proofs.
But for what purpose, though?
To make the connection clearer for Your Honor and the record.
Well, no, I understand. I understand what brought the officer from one location to the next. But I'm just being very careful with the words. I'm listening to you and I'm just making sure I understand the representation. I suppose I interrupted you because I heard you say what the officer provided in terms of the felonious assault. And that's why I began my inquiry, because he didn't really provide much, because I sustained the objection.
Your Honor.
But he did indicate why he went to one location and then why he went to another. So I'm listening. I'm listening. And so you're looking for a bind over on the matter.
I am, and I am asking that you allow me to reopen the proofs to more clearly connect.
And if by doing so, you would be asking the officer to provide testimony that is considered hearsay, I think it would be futile for me to allow you to reopen the proofs.
Your Honor, given the motion and the request for an evidentiary hearing and the suppression of the evidence, Your Honor, I believe that a deviation would be appropriate. And to establish not only why this evidence should not be suppressed, but in addition, more thoroughly establishing the corpus delicti of count one.
Okay, that request is denied. I don't see that there's anything that recalling that officer or reopening the proofs would allow to be brought forward without using hearsay. So that
and Your Honor,
is denied.
The people's argument would be that it is an exception or an exclusion to hearsay. The complaining witnesses were making a police report to further an ongoing investigation, which under
that request to reopen the proofs is denied. Your response to the argument for bind over, Mr. Clance?
Judge, at this particular time, respectfully, I know that this is a tough case for the prosecution, which is why I put forth the brief memorandum in advance. Judge, the bottom line is, and first, before I even get to the search issue, I'm just gonna say that from the proof's perspective, right? You have an individual that's in the front passenger seat of an SUV. There's an individual in the back passenger seat, and there's an individual in the front driver's seat. And then there's a firearm that's recovered behind the driver's seat. There's no testimony from a connectivity perspective that would establish probable cause or a question of fact other that this was Mr. Hicks's weapon. So they don't even, before I even get to how the weapon was recovered, from a connectivity perspective, in terms of the proofs that are sufficient for carrying a concealed weapon, there's no testimony that he was seen with the weapon, that the officer saw him in closest proximity to where the weapon was recovered, nothing. And that's why I was willing to stipulate to where he was seated in the vehicle, because it's right on the body cam. I know the court didn't see the body cam, but I did show it to counsel, and that's why we had a stipulation. But he's not even, the two other occupants are closer to the gun than he is, right? So this is why we wanted to place the prosecution on notice about the particulars of this file as it relates to that. And then on top of that, Officer Tatum says that he comes to a vehicle that's legally parked, that's parked in a residential area.
Objection, he did not say any of that. So counsel is now stating facts that are not in record.
This argument, Judge, am I gonna be, I didn't interrupt counsel.
Please proceed.
So this is a residential area where the vehicle is parked. These individuals are parked in a vehicle. And the officer walks up and says that I ordered them out of the car because I felt that there might be a gun in there. That's not probable cause to search a vehicle. It's not illegal to have a gun in the car. It's not illegal to transport a firearm. And he didn't know whether or not the firearm was properly transported, even if he thought that one might be in there. So that's just not how you do these cases at all. And Officer Tatum's a seasoned officer. He's been on the job 21 years. It's simple. You go up to the car, you ask them, do they have any objection to him searching the vehicle? You ask, do you have a weapon in the vehicle? If the people say yes, and we see this all the time. Yes, I have a weapon in the car. Yes, I'm open carrying. Yes, and a lot of times people take it. He didn't do any of these things. By his own admission, he walks up to the car, removes the occupants from the vehicle, handcuffs them, and searches and has them then searches the car because he thinks there might be a weapon there. That's not how it works at all. And then on top of that, because he, of course, by his own admission, by their own actions, because he has no idea whose gun it is, they arrest everybody. But it's only Mr. Hicks that's sitting here. That's just not how it works, Judge. The people have failed from an evidentiary perspective to substantiate the search from a probable cause perspective, and on the proofs for what it is for carrying a concealed weapon. There's certainly not enough here to place this on a passenger in a car. He's not in constructive, you gotta be in constructive possession of the vehicle if you're the driver. And then after that, it comes to proximity. Someone's sitting in the back. They don't even charge that person, but Mr. Hicks is charged. And then all this talk about felonious assault. I mean, I know the court is going to take judicial notice of the fact that my client is not charged with felonious assault. He didn't assault anyone, and the complainant's never made an allegation of an assault, which is why he's charged with a misdemeanor. So for those reasons, for all of those reasons, Judge, this case should be dismissed today.
Response?
Your Honor, the defendant is within arm's reach. The officers, when they arrived on the first scene, spoke with the complaining witnesses, who provided,
Complaining witnesses, Judge, there's no complaining witnesses.
I've been referring to them as complaining witnesses this entire time.
That's improper.
So,
Please proceed.
they responded to that location and spoke with the occupants of the house. Based on that information, the description of who it was, who it was that committed an alleged, I'll say alleged, felonious assault in conjunction with the vehicle that it was in, provided the officers probable cause to go and conduct further investigation, Your Honor. The officers had probable cause to believe that a crime had been committed. And Your Honor, I believe that the testimony was that it was found in the pocket of behind the driver's seat. That's not open carrying, Your Honor. The gun is within reach of the defendant. And I believe that the people have met their burden for bind over.
Okay, thank you. Mr. Hicks needs to make a determination on whether or not there is sufficient testimony that has been presented here at this stage. And the burden on the prosecutor is to establish by a probable cause standard whether a crime was committed, City of Detroit, County of Wayne, whether you probably committed those crimes. In this case, that crime, one count is a felony, one is a misdemeanor. The court has jurisdiction over the felony, this court. And my concern, and I think it's fairly obvious, my concern is the nexus between the defendant and the firearm that was recovered. there is an aspect, there's a void in terms of connecting the dots. Certainly, I understand what the officer did in responding to the initial police run, and then in turn receiving information that prompted him to further investigate, was given a location of a vehicle that matched the description. That was all that came out on the record. The content of the conversation between those individuals that the officer spoke to at the initial location on Pearson Street, that did not come into the record. And so when the officer approaches the vehicle, certainly he is concerned that there might be something in that vehicle. A firearm is what he had testified to, that came out on the record. And after having the individuals exit the vehicle, he did find a firearm that was recovered based on evidence. The testimony was that the vehicle was occupied 3 times, 1 male, 2 females. Again, no testimony as it pertains to what specifically he was looking for in terms of gender, etc. But there was obviously 2 females, 1 male, which means one of the females must have been driving that vehicle, someone other than, for certain, someone other than Mr. Hicks, who there was a stipulation was in the front passenger seat. And while that firearm was recovered from that vehicle, there were 2 other individuals also in that vehicle, and there was no further, the testimony is rather, the record is rather vague as it relates to the connectivity between the defendant and the firearm. I don't know if that was done on purpose or for some other reason, but probable cause is a level of burden that must be met. And I'm not satisfied that the prosecution has met it at this stage. So I am going to dismiss this matter for insufficient evidence. And there is one other case that still remains. The misdemeanor, however, is going to remain. There's a pretrial that will be set for the misdemeanor. What date can we get?
Is the court then,
I'm dismissing the felony, count 1, and the misdemeanor will go before Judge Bryant.
On August 18th.
August 18th. This court doesn't have jurisdiction over the misdemeanor.
Very good.
So that will be hashed out before Judge Bryant. As it relates to 2006125, are we ready on that?
Yes, Your Honor.
Any preliminary matters before we begin that matter?
I just asked that my officer in charge be allowed to remain in the courtroom.
Okay. Same officer in charge?
No, ma'am. This will be Detective Alan Austin.
Thank you. Good morning to you, sir. Detective Alan Austin?
Yes.
Traditional spelling of both?
Yes.
Okay. A-L-L-A-N or E-N?
E-N.
E-N. Thank you. First witness?
Your Honor, at this time, the people would call to stand Officer Amir Amin-Ra.
Okay. Good morning to you, sir.
Good morning.
Could you please state your first name and state your first and last name and spell both for the court reporter?
Amir Amin-Ra, first name A-M-I-R, last name A-M-E-N-R-A.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth?
I do.
The truth and nothing but the truth.
I do.
Thank you. Make your way over here. This half gate will open up towards you once you're settled coming up. And once he's settled, you may proceed.
Could you please restate your name for the record?
Amir Amin-Ra,
And are you currently employed with the Detroit Police Department?
I am.
In what capacity?
as a police officer assigned to the 8th precinct.
How long have you been employed with the Detroit Police Department?
A little under 5 years.
Were you employed in that capacity on October 13th, 2020?
I was.
Can we close the door, please?
So October 13th, 2020, did you work on that day?
I did.
Were you by yourself or with a partner?
I was with several partners.
What are your partners' names?
Just a few partners that day were Officer Stewart, Officer Rodriguez, and I was also with one of my sergeants, Sergeant Lewis.
Sergeant who?
Lewis.
I'm sorry, officer in charge, could I trouble you to close that door to the hallway? I appreciate it, thank you.
Were you in full or modified uniform?
A modified uniform.
Could you describe what that looks like for the court?
Black shirt, green tactical pants, and a black weight-bearing outer carrier. Vest carrier.
Was your name and or badge displayed in any manner?
Yes, ma'am.
Where?
On my chest.
Similar to what you have now?
Similar, yes.
Were you on foot or in a scout car?
The investigation started in a scout car. Well, actually, I was in a department-issued red van accompanied by 2 fully marked vehicles.
And did your duties as a police officer take you to the area at or near 17146 Murray Hill?
They did.
Is that location in Detroit?
It is.
Wayne County?
Yes, ma'am.
What is that location?
Residence at that location.
And so you mentioned you were in a raid van.
Yes, ma'am.
What is the reason that you were in a raid van going to 17146 Murray Hill?
Well, on that day, my crew had just got done executing a search warrant at another location. We were en route back to our base when we observed a crowd consuming alcohol in the street in front of that location that you mentioned earlier.
So after observing this crowd, how many would you say were in the crowd?
Roughly between 5 to 8 people.
And you said that you observed consuming alcohol. How do you know that they were consuming alcohol?
There was an open container of alcohol in their hands and possibly in a vehicle. I don't recall that if there were open containers of alcohol on a vehicle, but it's absolutely in their hands.
I'm sorry, I couldn't hear that last answer.
I said I cannot recall if there was open containers of alcohol on one of the vehicles near the crowd, but they were holding open alcohol.
On one of the vehicles?
Yes, I couldn't recall that.
So are we talking beer bottles, liquor bottles, or something else?
Liquor bottles.
Like full, like pints, or are we like Mike's Hard Lemonade or
I
something
don't
like that?
recall. There was bottles and cups.
Okay. So what, if anything, did you do in response to this observation?
Upon observing that, my sergeant who was operating the van I was riding in traveled south on Murray Hill toward the group. At that time, the group made eye contact with our vehicle, and some of the individuals who were consuming alcohol started to walk away westbound off the street beside a minivan that was parked there.
So were these people on the street or the sidewalk?
Initially, they were in the street beside that van. So we continued southbound. My sergeant stopped our vehicle, and everyone in the van and the 2 fully marked scout cars exited our vehicles to investigate the group for open intoxicants.
So after getting out of the raid van, what, if anything, did you do?
While my other crew members investigated the individuals in the street, I investigated the vehicle, the van that was right beside the group. That was occupied multiple times.
So when you say occupied multiple times, does that mean, do you mean that there is more than one person in the vehicle?
Correct.
How many people were in the vehicle?
I do not recall how many were in the vehicle. There was occupants in the front seat, and there was a individual sitting on the rear floorboard, and the back door was open of the minivan.
And do you see any of the occupants that were within the vehicle here in courtroom today, in the court today?
Yes, ma'am.
Could you please point to this person and tell me something that they're wearing?
The young man seated to my left with the gray sweatshirt with, I believe, Mickey Mouse on it.
Your Honor, may the record reflect that the witness has identified the defendant.
Record will so reflect.
So after approaching this vehicle and observing the people inside it, what, if anything, did you do next?
Well, at that time, I observed the individual I just referenced sitting on the floorboard of the minivan, and I immediately recognized that he had what appeared to be a pistol inside the waistband, pistol clip inside his waistband.
So a pistol clip.
Correct.
Would that be on his left-hand side or his right-hand side?
Well, not a pistol clip, but the clip to it inside the waistband holster. At this time, I didn't see a weapon. I just saw what I recognized as a clip to a holster.
And how did you recognize that?
Well, I see them every day. I come across several people a day who have inside the waistband holsters. I wear one off duty, so I know what the clip looks like to the holster.
So after observing this holster clip on the defendant, what, if anything, did you do next?
As my partners and I approached him, he gestured, looked down and pointed toward the clip. At this time, he didn't verbalize anything at all. He didn't state that he was concealing a weapon, that he was a CPFO or anything like that.
And by he, you mean the defendant?
Correct.
So he was gesturing down to where the clip was.
Correct.
And what, if anything, happened next?
At that time, my partner, I believe Pio Rodriguez, lifted his shirt and recovered a loaded firearm.
And did you observe Officer Rodriguez do this?
I did.
Did the defendant say anything at this time?
I don't recall him saying anything. At that time, I asked him if he had a CPO.
Do you recall what his answer was?
I did not have a CPO.
So after the firearm was removed, what, if anything, happened next?
At that time, after it was established he didn't have a CPL, he was arrested for CCW.
And you said that they were in a van?
Yes, a minivan.
Were the doors to the minivan open?
The rear door was open.
So would that be like a sliding door or a traditional car?
If I recall correctly, it was a sliding door.
On the driver or the passenger side?
The passenger side.
I have nothing further for this witness.
Cross-examination.
Police Officer Amin Ra, good morning.
Good morning, sir.
Now, you had indicated on this particular day that you were in a raid van, is that correct?
That's correct.
What were you doing in the area?
We're en route back to our base from a student search warrant.
Okay. Now, this particular street that you're on is a residential street, is that correct?
That's correct.
This is the middle of the afternoon, is it not?
It is.
Okay, so it's light outside, broad daylight, right?
Yes, sir.
And there were some individuals that were congregating in the street, is that correct?
That's correct.
Now, ultimately, did you issue a citation to anyone for consuming alcohol in public?
I personally did not. I'm not sure if any of my colleagues did. There was a lot of us out there that day.
Okay. Did you see Mr. Hicks with any alcohol?
I didn't. I did not see him consuming any alcohol or with any open container in his hand.
Okay. And in actuality, like all of these gentlemen, when you guys were driving down the street, they all walked off to the street. Is that correct?
Not everyone. We had a few walk towards the van, a few stayed there, and were investigating the street.
Well, let me ask you this. If they had stayed in the position that they would have stayed in as you guys were driving down the street, would they have obstructed the driver's pathway on the street?
I would say so. I think that's fair to say, yes.
Right. So these individuals are essentially, although they may have been drinking, they're also moving so that the vehicles can go by. Is that correct?
Well, let me scratch that, I'll withdraw that question. In the absence of them being able to move, it would frustrate the driver's ability to traverse down the street, is that fair?
If they stayed in the position they were in, yes.
Yes, okay. And ultimately, you would agree that Mr. Hicks then goes and sits down inside of a van that's parked on the side street, correct?
I can't say that, I didn't see him, personally, I didn't see him go sit down. He could have been seated there already. There was a lot of moving parts there. I can't testify to that, maybe one of my partners could, but I can't.
Would you agree that officers immediately grab Mr. Hicks once they approach the vehicle physically with their hands?
As I approached him, I saw that clip, and we made contact with him.
Okay, but what I'm asking you is, like, you're one of the closest officers to the van, is that correct? I know you're not first out of the van, but the officers that's first out of the van are right in front of you, correct?
Correct.
They're within your eyesight, right?
Yes, sir.
And would you agree with me, as my question is, they immediately grab Mr. Hicks when they approach the vehicle, is that correct?
I can't recall if they immediately grabbed him. No, I can't recall that, sir.
Were you wearing a body cam on this particular day?
Yes, sir.
Okay. Do you think if I showed you some contents of your body cam, you would be able to identify it as a point of reference for what happened on that particular day?
It would absolutely help, yes, sir.
Court's indulgence, Your Honor.
Yeah, I've already enabled share screen.
Thank you. As you take a look at the screen, that's your name in the lower left-hand corner, is that correct?
Yes, sir.
And do you recognize the occupants of the vehicle as being consistent with the individuals that were with you on that particular day?
I do.
At this time, the defense would move for admission as defense exhibit A.
Any objection?
Yes, Your Honor, as was presented as being used to refresh the recollection, not for substantive evidence.
You have an objection to it being entered as substantive evidence?
At this point, yes, Your Honor, because
What is it?
Because it would be improper witness memory refreshment.
Never mind.
Were you going to say something? So it's a twofer. Mr. Clements is obviously using this to refresh the officer's recollection, but he's also, I guess, seeking its admittance at this time, and you're objecting. You're objecting to which one? It being used, anything can be used to refresh one's recollection, so I don't think you're objecting to that. You're objecting to it being admitted as evidence because?
At this time, as substantive evidence, because the initial request was for memory refreshment.
But now he's also requesting for it to be admitted, and the basis for your objection would be that
well, Your Honor, for one, it contains hearsay. And additionally, the offers to refresh can be whatever it is, but for substantive evidence, Your Honor, the witness, I believe that the order of operations is what is incorrect here.
okay, well, you can certainly proceed to play it, and then I'll hold my ruling in abeyance as it relates to the admission of its as an exhibit for the defense.
Officer Amara, thank you, Your Honor. This is a fair and accurate depiction of the circumstances that you're here to testify about today. Is that correct?
That's correct.
You recognize that this occurred almost a year ago. Is that fair?
That's correct.
You conduct operations and investigations on a daily basis, correct?
Yes, sir.
Make arrests on a daily basis, right?
Yes, sir.
Would you agree with me that your body cam is going to be a more accurate reflection than you could be in terms of what you're testifying to because of the fact that it's actually recorded of the event?
On certain aspects, yes.
Thank you. At this particular time, Judge, I move to publish with the court holding the ruling on the objection is made.
Yes.
after having an opportunity to watch this exhibit, would you agree with that almost immediately officers grabbed Mr. Hicks when they approached the vehicle?
It appears that one of our partners did make very quick contact with Mr. Hicks, but he could have observed the same thing I did immediately with the pistol, the clip for that holster in his waist.
That's fair, but what I'm saying is, like, as it relates to my question that I originally asked you, you'd agree with me that it's very quick that these officers physically grab Mr. Hicks once they approach the vehicle, correct?
That's fair, but we have a trained guy, we observed that a lot, so.
I understand that, but
Yes, sir.
one step at a time, right? And of course, what I'm asking specifically is that the grab occurs very quickly. Is that fair?
Your Honor, I'm going to object as to the questioning as argumentative, this often, and as well as asked and answered. Argumentative in the fact that this officer has testified that he doesn't know why this other officer did what he did. And asking him to speculate and comment on what another officer did or the quickness or lack thereof of what another officer did is speculative and argumentative.
I don't know that it's argumentative, but certainly this officer is not the best officer to ask that question of why another officer did another thing, but he did answer it. I think there's he gave an answer as to what he assumes happened there. But please proceed.
If I may add, Judge, I didn't ask him that though. I just provided him leeway to answer. My question was whether or not he would agree that officers grabbed Mr. Hicks very quickly. He said yes and then provided context.
Yes, he did. So
And
please let's move on.
Thank you. I'm finished.
Oh, okay. There's no more questions you have, Mr. Lynn?
On that particular.
Oh, okay.
Now, did you ultimately recover the firearm in this particular case?
No, my partner, Officer Rodriguez did.
Okay, but not you though, correct?
No, sir.
Nothing further, Judge. Thank you.
Okay, any redirect?
Mr. Hicks never provided you with a CPL.
No, ma'am.
And in fact, he admitted to not having one.
Yes, ma'am.
And was the gun pulled from his waistband visible to the naked eye?
Not to the naked eye, no.
I have no further questions.
Thank you. You may exit the courtroom. Thank you so much, sir.
Y'all take care.
Next witness?
The people have no further witnesses.
Okay. Mr. Clements?
No witnesses on behalf of Mr. Hicks.
Is there a motion?
Yes, Your Honor, at this time, people would motion for bind over.
Mr. Clements, argument?
There's the argument that I would make first is that the officer indicated that when he looked at Mr. Hicks's waistband, he felt as though that he may have a clip that could potentially have been a firearm. Judge, but he's not the one that initially grabbed Mr. Hicks and made contact with him. And really, Judge, I'm just very disturbed by what occurred here, that in the middle of broad daylight, that multiple scout cars would just ride down a residential street. And then when Mr. Hicks is sitting in a van, that they can just run up to a van and just snatch him out of the car. Right? I'm just not familiar with what aspect of policing that is. I'm not familiar with what aspect of Fourth Amendment jurisprudence that is, that allows them to do that, that allows them to basically ask no questions, no correspondence. And I do think that it's telling that the officers who essentially grab Mr. Hicks, who make physical contact with him, aren't here, that they weren't subpoenaed, that they don't testify. Because essentially, they're the ones that effectuated the search. Like Officer Amin Ra said, but for them grabbing him and manipulating his clothing, they would never have known that he had a firearm, right? So we have to understand and know why that occurred and why that happened. And when I look at this particular case, when I look at that video, it's just disturbing that they could just ride down the street, run up to a car, basically snatch somebody out of a van or a moving vehicle, and then manipulate their clothing and see if they have a gun. Now, I understand that there's a focus and emphasis on getting guns off the street. I do. And I think that that is good work and the police need to do it. But it still needs to be done respectably, reasonably, and it needs to be done properly. And that, what you saw on that body cam video, that is not it. That's 100% unacceptable.
Thank you. Well, what we did see were officers that were trained well, from the testimony provided here today from the prosecutorial witness, did act very swiftly and thank thank goodness. There was definitely articulable statements placed on the record, unlike the previous case, that causes this court to believe that the prosecution has met their burden by a probable cause standard. The crime was committed in the city of Detroit, county of Wayne, and that you, sir, Mr. Hicks, that was identified as the individual for which the officer indicated he saw a clip hanging from your waistband, not hanging, but on your waistband. Action was taken and a firearm was recovered. That firearm was placed on evidence. You were identified as that individual. And there is, at the very least, a question of fact that has been presented. And the court is going to bind over as charged to the circuit court for further proceedings with an AOI date of August 25th. Did you wish to state something more, Madam Prosecutor?
No, Your Honor.
Okay, thank you. We're all set. Again, the pretrial on the misdemeanor is August 18th
Very good, Judge.
on the
Thank you.
previous case.
We have a Hilton part that was scheduled, Judge, so we're gonna need to do that first. Do you have anything that we can call this real quick?
No, unfortunately. I have one that Hussein, it sounds like it's gonna be a hold. The issue I'm having right now is we need 2 Bengali interpreters and only defense's Bengali interpreter has special. So I don't know.
There's 2 ordered though.
Yes, there were, and I saw that on the ROA. And the interpreter said he thought he saw him
2
on
interpreters.
4.
Okay. Well, I can call upstairs and find out about
Yeah,
that.
thank you.
But we're gonna need to do this Hilton part
Yeah.
first. If there's any quick dismissals or anything that anyone has that we can call before.
Yeah, no,
we start this.
that's my 11, and then everything else is 11:30, so.
I hope we can
How you
finish
doing,
this up.
Judge?
Good, how are you?
Good.
Okay, good to see you. Let's do this now.
Good morning, Ms. Cal. Yeah. Hello, Judge. How are you? Good to see you. Mr. Strong?
In case our co-defendants and even one of your clients are.
Okay, I can send call. I'm gonna call a quick paper. Are they here? Calling parties on Clark and Christian. Case number 2058372. The people of the state of Michigan versus defendant number 1, Willie Clark. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3, weapons, felony firearms, second offense notice. Count 4, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Defendant number 2, Marcellus Christian, is charged with count 5, assault with a dangerous weapon, felonious assault. Count 6, weapons, felony firearm. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brent Bailey on behalf of the people, P84009.
Good morning, Your Honor. Wanda Cal, P34369 on behalf of Willie Clark.
Ronnie Strong, 34545, Karen on behalf of Mr. Marcellus Christian.
Okay, and your client, Ms. Cal?
Your Honor, Mr. Clark did get released from federal custody. I had contact with him in June. He had a court date in front of Judge King in June, did not appear for that, and I have not heard from him since.
Well, this matter was set for.
And I sent him a letter informing him of today's date and time with Your Honor.
Oh, okay, thank you. This matter was set for 11 a.m. It's currently 11:20. Have we received a phone call from Willie Clark, Madam Clerk?
No, no calls.
Okay. What is Willie Clark's current bond? I don't see any indication.
It says $10,000 personal on my appointment slip.
No GPS setting.
That's all it says on the appointment slip.
Yeah.
Well, he was in federal custody, so I assumed they didn't have a GPS tether on him. He was in
Oh.
Kentucky. Okay.
Yeah. Okay, is there a motion?
Your Honor, at this time, the people would motion for KPS.
Actually, Judge, it was 15,000, 10%.
Okay. Well, again, given the time frame that we are looking at now, and the fact that the defendant, Willie Clark, has failed to join the party here, I am going to grant the motion for Capias to issue. Previous bond is going to be revoked, and new bond is going to be set at $20,000 cash or surety.
Thank you, Your Honor. Have a nice day.
Thank you, good to see you.
You as well.
Mr. Strong,
Yes,
did
Your
your
Honor.
client state his name?
Yes, Your Honor, as to Mr. Marcellus Christian, I spoke to Mr. Christian yesterday, and I told him that he had to be here this morning at 11 o'clock. He assured me that he would be here. I talked to him this morning about 10 o'clock. He said he was on his way down, he was waiting for his grandmother to come give him a ride.
Oh,
I just talked to him out in the hallway about 3 minutes ago.
oh, he's in the hallway?
No, I called him on my cell phone, and I talked to him, and he said he was still waiting for his grandmother to come give him a ride. So that's where we're at with Mr. Christian.
Okay, well, that is also unfortunate, as this matter was set back in, I don't know, because he was Capias in January, and it was reset apparently sometime thereafter.
February 24th.
February 24th. And so that certainly is a considerable amount of time for which one could arrange travel down to this court. It concerns me that he is not here, and it's now 22 minutes past the start time of the examination. Is there a motion?
People would motion for KPS.
KPS is going to issue, previous bond is going to be revoked. New bond is going to be set at $20,000 cash or surety. In the event that you walk in the hallway and he approaches, certainly you can just walk back in, and we will get this back on track. Probably not be able to do an exam today. I don't even know if the prosecution had witnesses or not, but in the event that you walk out of the courtroom and then suddenly are able to get in contact with him, we generally don't enter the KPSs until around 2-ish. So you certainly can zoom in, and then we can set it aside and get back on track. But if it's after the KPS has been entered, so again, it's after around 2 o'clock, then he will have to avail himself in the normal course of an open warrant.
Judge, I can zoom in with him about 1 o'clock.
Well, we won't be here at 1 o'clock. We'll be on our lunch recess, but 1:30 would be fine.
We'll zoom in at 1:30.
Okay, and so I am going to sign this KPS, but it won't be entered as I indicated. And I certainly will go on the record if he's present and set it aside and get it back on track with a little bit of a discussion that we'll need to have regarding why he wasn't here, but we'll get it back on track, okay?
Yes, sir.
All right, thank you so much.
Nothing else quick that we can do? Calling parties on Moore. Gregory Moore, case number 2058839. The people of the state of Michigan versus Gregory Moore. The defendant is charged with count 1, operating while intoxicated. Third offense, notice felony. Count 2, alcohol, open container in vehicle. Habitual offender. Fourth offense, notice commission of a felony with a motor vehicle advisory. This is scheduled for preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. May it please the court, Wayne Johnson on behalf of Gregory Moore, who is present to my right.
Could you please state your name, sir? Thank you. All right, this is a held and part examination. Let's pick up where we left off.
Your Honor, at this time, the people would call Trooper Brad Connor to the stand.
Okay.
Brad Connor.
Good morning, sir.
Morning.
trouble you to please state your full name and spell your first and last name for Madam Court Reporter.
Trooper Brad Connor, BRADCONNER.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. If you could make your way to this pack gate, it opens up towards you. And once he's settled, Madam Prosecutor, you may proceed. Thank you, Your Honor.
Good morning.
Morning.
Could you please restate your name for the record?
Trooper Brad Connor,
Now, I noticed that you indicated that you were a trooper. Who is your employer?
the Michigan State Police.
How long have you been employed with the Michigan State Police?
It has been 13 years.
Were you employed with the Michigan State Police on February 21st, 2020?
Yes, ma'am.
Did you in fact work on that date?
Yes, ma'am.
Did you have occasion to respond to an incident on West I-94 freeway near Connor?
Yes, ma'am.
And why did you, is that in the city of Detroit?
Yes, ma'am.
Wayne County?
Yes, ma'am.
What, if anything, did you observe when you arrived there?
It was a single vehicular crash, vehicle laying on its side just under the overpass. And emergency personnel was loading a person up to take him to the hospital.
And to your knowledge, how many people were in that turned vehicle?
It's a single occupant.
And do you see that single occupant, and do you see the occupant here in the courtroom today?
Yes.
Could you please point to him and tell me something he's wearing?
Plaid style shirt, button-up shirt.
Your Honor, may the record reflect the identification of the defendant?
The record will so reflect.
So after you made the scene, what, if anything, did you do next?
EMS was loading him up on an ambulance to take him to the hospital. We processed the scene, and I went to the hospital to follow up with the occupant of the vehicle.
How many people were you working with on that day?
There were several. I mean, are you referring to emergency personnel or troopers?
Troopers.
Only one I recall having any involvement was one Trooper Eastlake. I think Trooper Green was there as well.
So you, after arriving at the hospital, what, if anything, did you do?
I made contact with the occupant of the vehicle and requested, or went through a chemical test rates and requested a consensual blood draw.
And can you describe for the court what is strike that? So when you were making contact, how did the defendant consent to the blood draw?
I would have advised them that I would need to read what's called a chemical test rates off the back of a DI 177. It's a official form. I would have read through there and asked him if he would take a blood test.
And what was his answer to that?
I don't remember a quote, but he agreed to consensually take a blood test.
And after Mr. Moore gave consent, what, if anything, did you do next?
I would have advised the hospital that it was a consensual blood draw. They would have sent qualified staff over to the bed where we were staying, and I would have provided the hospital staff with a blood kit for the blood draw.
So did a nurse or other hospital staff arrive at the bed where Mr. Moore was for this blood draw?
Yes,
And when this person arrived, what, if anything, did you do?
I would have provided them with a blood kit. That blood kit would be sealed. In their presence as their witness, I would have opened the blood kit, broken the seal, and provided them with the blood modules inside of it, an iodine wipe for cleaning the area that the blood draw is going to take place in, and started filling out the paperwork that's inside that kit.
And did you in fact do all of those things?
Yes, ma'am.
So what, if anything, happened after the nurse arrived?
When the nurse arrives again, in their presence, I'll open the blood kit.
Well, Your Honor, I'm gonna object to him saying what his practice is. I want him to say what happened at this particular.
Objection sustained.
Your Honor.
The objection is to the terminology that he's using. I would have, please, let's reframe the testimony, the questions and whatnot to what he did do. You can certainly ask a line of questions with regards to what do you normally do, but you're asking what he did do and he's saying what he would do. So two different things. So if you want to clarify, you're more than able to ask those questions. Trooper rather, I'm sorry, what is your normal practice? And you can run through that whole gamut and then ask, what did you do in this specific instance? Because there is a distinction.
Yes, Your Honor.
You wrapped it up, actually. She did clean it up on that last series of responses where he said would have, when she gave that final question of, and did you in fact do this? So perhaps that's what she's planning on doing here, but the objection is sustained.
Thank you, Your Honor.
So
I don't mean to complicate it. You can ask the same questions, but after each question, if he says would have, then please follow with, did you, in this instance, do that?
yes, Your Honor, I'm just remembering where I left off.
Oh, okay. What happened when the nurse came in?
So, thank you, Your Honor. So after the nurse arrived, and you initiated the kit, what, if anything, happened next?
I opened the kit in her presence. I took out the contents of the kit, provided her with the little vials or the modules for the blood. I gave her the iodine pad. She started drawing the blood. At that time, using the clock in the hospital, I would have marked down, or I did mark down the time that each blood vial was drawn. Both marked it on a sticker that goes on the tube of blood, as well as the form that I submit to the Michigan State Police lab.
And did you observe the nurse complete the blood draws?
Yes.
After the blood draws were completed, what, if anything, happened next?
After the blood draws are completed, I put the modules inside. There's a little cardboard container inside the blood kits. They get stored in that. I put it in a plastic bag that also comes with that blood kit for storage. Then I put my initials on the new seal, and again, in front of the medical staff, I seal the kit and put a new seal on it.
And does this box that now contains the blood samples have a evidence tag number?
There's not an evidence tag number on the box. It's just a box that's sealed and sent to our Michigan State Police laboratory.
And so after sealing the box, or I guess resealing the box, what, if anything, did you do next?
After sealing the box, I would have provided Mr. Moore with, or I did provide Mr. Moore with the paperwork that he gets a copy of the DI 177. And I would have taken that box back to the post and it gets sent to the Michigan State Police lab.
Now, did you, after leaving the hospital, take the sealed box back to the post?
Yes, ma'am.
And after taking it back to the post, what, if anything, did you do with it?
I put it in the departmental mailbox. It's our department sends out a truck every day that picks up interdepartmental mail, and then it gets sent or taken directly to the lab.
And was the blood that you sent tested?
Yes,
And were results returned to, were the results returned to you?
yes,
Would you recognize those results if I showed them to you?
yes.
Let the record reflect that I am showing defense counsel People's Proposed Exhibit 1. Permission to approach the witness?
Yes, ma'am.
Trooper Connor, what is it that I have just handed you?
This is a printout of the Michigan State Police Forensic Science Division's lab reports.
And is it a fair and accurate representation of the results that you received back?
Yes, ma'am.
Does it appear to be altered in any way?
No, ma'am.
Your Honor, at this time, the people would move to enter the People's Proposed Exhibit 1 into the record.
Do you hear voir dire at all, Mr. Johnson?
No, not at this time.
That will be admitted as People's,
Proposed Exhibit 1, or People's 1, Your Honor.
People's 1. Will be admitted, thank you.
Officer, what were the results of the blood draw conducted on Mr. Moore?
This is 0.25 grams of alcohol per 100 milliliters of blood.
Your Honor, I have no further questions at this time.
Cross-examination.
Thank you. Good morning, officer.
Morning, sir.
Okay, so apparently, February 21st, you were sent to a scene of an accident in Detroit around 994.
Yes, sir.
And when you got there, you said you saw my client getting on a stretcher.
I believe he was getting loaded into an ambulance on a gurney, yes.
So you did see him. That was, when you got there, that's what you saw concerning him.
Yes.
And where was the car?
The car was on its side, on the left, sitting on the left shoulder, left lane.
Okay. So you didn't actually see the accident?
No.
And you didn't see my client on the driver's side of the car, correct?
Correct.
So you didn't really act, so you're just going by hearsay or whatever, that he may have been driving the car, is that correct?
Yeah, so yes, sir.
Because you don't, I mean, you don't.
I didn't see him in the car. So that's
Right, you
correct.
don't have personal knowledge that he was driving the car.
Correct.
He could have been a passenger, is that correct?
I suppose it could be correct. yes.
Objection, Your Honor. As to speculation, this officer has already testified that there was one occupant within the vehicle.
This is cross-examination. Objection overruled. You'll have an opportunity to redirect.
Thank you. Okay, so, you see my client being placed on the stretcher, and you find out that he's going to a hospital, is that correct?
Correct.
What hospital was it?
I don't recall the hospital, sir. I have to look at my report.
So you went to the hospital,
Correct.
okay, at what point did you see my client at the hospital?
What do you mean?
Where did you see my client at the hospital? Was he in his room, Was he in the emergency section? Where was he in the hospital when you saw him?
He would have been, I don't remember, but he would have been in one of the pods, I'm assuming.
So you don't remember?
I don't remember where he was located in the hospital, no, sir.
You don't remember where you saw him in the hospital? What was do you know if he was in his hospital room or where was he?
It would depend on what hospital he went, sir. I don't remember if he was in a room or if he was in one of the pods separated by curtains.
Okay. And what was your intention of having contact with him? Why did you have contact with him? Was that to arrest him?
No, it would be to get status on injuries for the report.
To get status on his injury?
Yep, and we also found a bottle of tequila in the car. I wanted to ask that as well.
You found a bottle of tequila in the car?
Yes, sir.
So you went to the hospital to find out about his injuries and to ask him about a bottle of tequila. Is that correct?
Yes, sir.
Okay.
Do me a favor,
And-
I muted her.
Oh, okay.
It's, Attorney
Okay.
Jefferson.
Okay. So let's talk about his injuries. What injuries did you see or find out that he had as a result of being involved in an accident?
I would have to look at the report, sir. I don't recall.
Can you look at your reports and tell me?
If it's documented in the report, I'll be able to tell you.
You have a copy? Will this refresh your memory?
Yes, sir.
The extent of his report. Madam Pro Tem?
Yes.
Thank you.
Okay. Okay.
It doesn't have any injuries listed in the report, sir.
So you didn't find out any information about his alleged injuries, is that correct?
It may be marked on the UD-10, sir.
What is the UD-10?
UD-10 is a crash report. It would be
Yeah.
filled out in conjunction with this, and it would list basic information in regards to injury.
So you don't put it in your regular report?
This is Trooper Eastlake's report, sir. This isn't myself.
Where's your report?
Should be in the documents there, sir.
Can we, get his report?
I talked to him.
But if there weren't major injuries, they wouldn't be listed in the report, sir.
Well.
This is-
Madam Pro Tem?
Yes.
Okay, now, can you now tell me anything about the injuries?
I don't have any injuries on there. Again, if it was minor injuries, it would be listed as a minor injury on the accident UD-10, but I may not have documented them in here. due
So
to them
you're,
being
so you're
minor.
telling me you went to the hospital primarily to check on his injuries, but you don't give any information about any injuries in your report. Is that correct?
That's accurate.
Objection, Your Honor. relevance as to whether or not injuries were actually recorded or not.
If I told you,
I'm sorry, as it relates to the objection, it's cross-examination. You can ask these questions. Objection overruled.
would you be surprised, officer, if I told you that he had some trauma to his head, his brain, as a result of that accident? Would that surprise you?
No,
Okay. But you didn't put any of that in your report, is that correct?
there's no injuries listed in the report, no, sir.
Okay. So, officer, is it possible that you really went there to make an arrest and not to really check on the status of his injuries?
No, that wouldn't have been my primary objection, or my primary mission.
Did you question him about the tequila that you found?
I did.
Now, you mentioned a chemical test rights.
Correct.
And when do you primarily do that? When do you use that?
Before I ask somebody to take a breath, blood, or urine test,
Okay.
I will read a chemical test rights to them verbatim off the back of a DI 177.
Okay. And isn't it, and aren't you to have them sign that as well?
No, sir.
You don't have them sign that?
No, sir.
And you're saying that, in your opinion, he understood what was going on?
I read it verbatim to him, asked him if he had any questions about it. He consented to a blood draw.
Now, officer, do you use a body cam?
I didn't have a body cam at that time. We were just assigned body cameras recently.
You're saying you didn't have one?
Didn't have a body camera on, no, sir.
Were you supposed to have one on and you didn't, or?
No, like I stated, we didn't have any issued to us at that time.
So you had no way to record anything that went on between the conversation with you and my client?
No, sir.
And you have no indication that he signed or authorized anything in terms of consenting to a blood test?
He verbally authorized it, sir.
And did you ask any questions to find out if he really had understanding of what he was consenting to when he consented to a blood test? Did you ask any questions of him? What steps did you take to make sure he was voluntarily consenting to a blood test?
Again, I read the verbatim, the chemical test rates off the back of the DI 177, asked if he had any questions about it, and asked him if he would consent to a blood draw.
Okay, and after you asked him those questions, what do you recall him saying?
He consented to it. I don't know verbatim what he had said, but he consented to a blood draw.
Now, you also mentioned that you give a package to the nurse that arrived at the scene. Is that
In the hospital, sir,
in the hospital, right?
I give a blood draw kit to the nurse.
Okay. And where does that blood draw kit come from?
Those are through my department. We get them through the department, through our lab.
Okay. Is that something you carry around with you?
I have one in my patrol car at all times.
Okay. And has that been used before?
Yes. Well, not that kit, but I've used them in the past.
Okay, so the kit was, this is a new kit.
Each kit is new, each one is sealed, and the seal doesn't get broken until it's witnessed by the nurses.
Okay. And so you're saying in front of the nurse, you broke the seal and gave her that in order to draw the blood?
Yes, sir.
I don't have any further questions.
Can you redirect?
No redirect, Your Honor.
Thank you, Trooper.
Yes,
May
ma'am.
exit the courtroom. Any further witnesses?
Where do you want
want the paperwork now.
Oh, if you could hand it to Madam Prosecutor.
Yes, ma'am.
Any further witnesses for the prosecution?
No, Your Honor, no further witnesses.
Mr. Johnson,
No witnesses, Your Honor.
motion?
Yes, Your Honor, at this time, the people would motion for bind over on all counts. We have heard today from Trooper Connor, who testified that on February 21st, 2020, he responded to the scene of West I-94 freeway near Connor here in the city of Detroit, Wayne County, where he observed a car turned on its side, Your Honor. That was the only vehicle that had been involved in the incident, Your Honor. And he observed the sole single occupant being removed from that vehicle and placed on a stretcher and taken to the hospital, Your Honor. After arriving at the hospital, the trooper conducted questions and an explanation of the defendant's rights, and after consent and a process by which the Michigan State Police provide the blood kit to the hospital, blood draw was done, Your Honor. That was then taken and tested, and it was just determined that the defendant had a blood alcohol content of 0.25 grams per 100 milliliters of blood, Your Honor. That is more than double the limit allowed for in Michigan, Your Honor. Therefore, I believe that the people have met the burden of probable cause for today's hearing, and I motion for bind over.
Well, Your Honor, we would have, I don't think prosecution has shown probable cause that my client was driving the car. The officer testified didn't see him driving the car. He saw him being put in a stretcher in an ambulance, and he saw him being taken to the hospital. There's also a problem with this consent. I think it could be a violation of my client's constitutional rights. There's no documentation of any signature saying that my client had knowledge of his consent, that he signed and allowed him to consent. My client, from what I understand, suffered some brain damage. I don't know, and without him looking into that and finding out what my client's condition is, I don't think my client can voluntarily give consent for the blood. So I would say that that's a constitutional violation. I'd ask that this matter would be dismissed.
Thank you. So today is a preliminary examination. It's a continuation of an examination. This was a held in part exam that continued today for further testimony. And I'm satisfied with the fullness of the record that has been presented here. As I've indicated, it's a probable cause examination. Probable cause to believe that crime was committed, City of Detroit, County of Wayne, that you, sir, probably committed that crime. We're focusing here on the felony, operating while intoxicated, third offense notice. And the trooper testified rather succinctly here today in conjunction with the commencement of the examination for which this court took notice. And the officer testified, the trooper testified as to his response to the making the scene of an accident. Vehicle was on its side, occupied one time. He did indicate that he saw his observation upon arrival was the defendant who he identified here in court today being gurneyed into an ambulance, which was taken to the hospital, and he indicated that he met the defendant at the hospital and asked him some questions. According to his testimony that was gone over rather thoroughly by both the prosecution and defense, he received consent for that blood draw that was testified to. He testified as to the protocols that he normally uses. He testified as to the protocols he did in fact exercise on this particular occasion with regards to the blood draw. The People's Exhibit number 1 was admitted, which contained the results of that blood draw, that being 0.25. Now, although there may not be a document that has the defendant's signature on it, what we do have is the testimony that's been provided here by the trooper, asked multiple ways regards to whether or not consent was given. And I'm satisfied that the prosecution has met their burden to probable cause standard. Crime was committed in the city of Detroit, County of Wayne, and that you probably committed that crime. The matter is going to be bound over to the circuit court for further proceedings with an AOI date of August 25th. That's going to be as it relates to count 1, the felony, as well as count 2, the misdemeanor, is going to travel along for the efficient administration of justice. Alcohol monitoring is going to remain in place. So obviously, there's no consumption of alcohol, no use or possession of any controlled substance unless prescribed by a physician. So if you have anything that falls within that category, please make sure you have a prescription that is always handy. Again, the AOI date is August 25th at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Let it have a good day.
You too.
Can you have Mr. Bowen come in?
Yes, ma'am.
Good morning, Mr. Miana.
Good morning, Your Honor.
Ms. Jefferson's Zoom.
Ms. Jefferson.
Hi, Judge. Hi, I apologize. I'm sorry. I didn't get this one. I put it in the wrong spot.
Were there witnesses on Bowen?
They have witnesses?
I don't know, I'm asking, are there witnesses on Bowen?
The calling parties on Bowen, case number 2061700. The people of the state of Michigan versus Brandon Lamar Bowen. The defendant is charged with count 1, weapons carried concealed, count 2, weapons, felony firearm, count 3, weapons, firearms, possession by felon, habitual offender, court defense notice. This was scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Thomasine Jefferson on behalf of Mr. Bowen, P42872, and Mr. Bowen is present.
Mr. Bowen, please state your name. Are you Mr. Bowen?
Yes.
Mr. Bowen, please state your name.
Brandon Bowen.
Thank you. Ms. Jefferson, you were supposed to be here.
I know, Your Honor. I apologize. I put it in the wrong spot. I know it got adjourned from before, and so because I would have never agreed to this one today. But I'm sorry. I apologize.
So apparently, Madam Prosecutor just responded that yes, there are witnesses here. What is your pleasure at this time? Did you want to converse with your client? I don't know if he has a cell phone.
Mr. Bowen, you still got your cell phone, the phone that you called me on?
Yes.
Can you call me again? I can just have about a few minutes, Your Honor.
Okay, we're gonna pass on this just for a moment. Thank you so much.
Thank you.
What's going on Robertson, Theory Robertson? Mr. Muhammad?
He's supposed to be here, he's at work, and I think he said he just zoomed in.
He was supposed to, it's an in-person exam, just where his client was at work, I guess. I'm not sure if he's on or not.
Were there witnesses? Did he zoom in?
I didn't see his name.
Sorry? Yeah, he said he's waiting in the Zoom. I know there is an officer here,
There is an officer here?
as far as I know.
Did you want to speak to your client about the possibility of a waiver?
I did, Judge, he wants to hold.
Oh, okay. Well, that therein lies the problem.
Calling parties on Robinson, case number 2061977.
Can we get the officer, please, that pertains to this matter? Thank you.
Yes, ma'am, I'm here.
The people of the state of Michigan versus Theory Moore Robinson. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carried concealed. Count 4 and 5, weapons, felony firearm. Habitual offender, second offense notice. This was scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Your Honor. Najad Mihan appearing on behalf of Mr. Robinson, E5971.
And your name, sir? Mr. Robinson, please state your name.
Yes, ma'am, my name is Theory Robinson.
Okay. So, Mr. Robinson, I guess the first natural question is, why are you on Zoom?
my attorney told me I had a court date today. He gave me the Zoom in number, I guess, to speak with you, man.
Yeah, so why are you on Zoom and not here in the courthouse? You were supposed to be here for a 10 o'clock examination?
I didn't know about that, man. I ain't getting nothing in the mail or I didn't receive any information on that.
What's the name of your street?
Excuse me?
What is the name of your street that you reside on?
Cranbrook.
Okay, so, yeah, a notice was sent out to that address, and we are here today for an in-person examination, and the officer apparently is here. Is there an officer that's here?
Yes.
Okay, that's your necessary witness, Officer Aileen?
No, that's Officer McDonald, Judge.
Okay,
She was present.
all right, so with that being said, your attorney's here, prosecution's here, I'm here, necessary officers here, you can probably see her in the camera there.
Yes, ma'am.
So, was your intention to waive the exam? Because if you want the exam, you know, we're all sitting here waiting for you.
I mean, I can join in. Right, we can take care of all this right now, man. Since we all here.
How so?
Oh, you said so? It's still got to be in person, or I can't just be right here on Zoom, or we have to reschedule this date or something?
Yeah, because your attorney is here, and this court is not really interested in doing a hybrid exam.
Hold on.
Where he's in one location and you're in another. So what we're going to do, if your desire is to hold this exam, the exam unfortunately is not going to be until we can naturally take this non-custodial matter, which will probably be December. Everybody is trying to, as best we can, honor each other's time.
The signal going in and out, man.
Okay, well, what I'm trying to just explain to you is that it's frustrating that you're not here. I'm trying to honor everyone else's time, but you need to also honor the court's time, the officer's time. She's been sitting in the hallway for this exam that was supposed to start at 10. Your attorney has been sitting here. I'm sure he's got 10 places he could be, has to be. And we've been ready to call your matter. So, Madam Clerk, can you assign a new court date?
Judge, we can do November 29th at 10:30.
November 29th at 10:30. Mr. Mahana, does that work for you?
I'm sorry, November 29th at 10:30?
At 10:30.
That's fine with me, Your Honor.
Okay. We will see you then.
Thank you, Your Honor.
Thank you.
And you have to be in person, Mr. Robinson.
So you say it's November 29th, and it's in court?
Yes, I'm assuming there's no furlough complication with that, officer? Officer, I'm assuming there's no furlough complication with that?
No, ma'am.
Okay. And yes, Mr. Robinson, the understanding is that you would be here in person.
Yeah, I apologize for that misunderstanding, man. I get it now, though, on the 29th of November at 1:30.
All right. No, it's at 10:30.
10:30.
Oh, excuse me, at 10:30, excuse me.
Okay, thank you. We're all set, thank you.
I was told Roberts is a dismissal. Is that true?
Yeah, and Johnson is what I.
Thank you, Judge. Have a good day.
Thank you, Mr. Mahana.
Calling parties on Roberts. Get the parties on Dunson for next. Can you have the Dunson party on Dunson next? Calling parties on Roberts, case number 2062489. The people of the state of Michigan versus Juan Rocio Roberts. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 3, child abuse, 4th degree. Count 4, domestic violence, habitual offenders. Third offense notice, this is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Good afternoon, Your Honor. Kathleen Tulas, here on behalf of Mr. Roberts.
And your number again?
6313A.
Thank you. And your name, sir?
Lon Roberts.
Thank you. Today is the date and time set for an examination. Are we proceeding to an exam today?
Your Honor, at this time, the complaining witness, Chauncey Chandler, is not present, and they were subpoenaed to be here for an 11:30 exam. Without their present participation, the people are unable to go forward as to counts 1 and 2.
Madam Defense, is there a motion?
Yes, Your Honor, I would motion for dismissal.
It is currently 12:07, and this matter was set for an examination at, was it 11 or 11:30?
11:30, Your Honor.
11:30. And the prosecution is unable to proceed in the absence of the witness. So I am going to grant that motion to dismiss count 1 and count 2, which are both felonies. They're dismissed, however, without prejudice. And Mr. Roberts, what that means is that it is possible for this matter to be reissued. I know, it sounds confusing, doesn't it? Because it's August 4th, and I'm telling you that I'm dismissing it, but then I tell you that. Which is why I always like to pause and explain that whenever a matter is dismissed and it has the trailer language behind it, without prejudice, which is the situation here, the prosecutor has the discretion to reissue. We know that the witness is not here, but we don't know why. And if the prosecutor goes back to his office and makes some phone calls and finds out that there was some issue that had arisen preventing that witness from appearing, it's within this prosecutor's discretion as to whether or not he thinks it's appropriate to reissue. And I always like to pause and explain that, because for someone that walks out of the courtroom thinking their matter is dismissed and can never come back up, that can be a real eye opener when they get word if there is a reissuance. So you understand?
Yes, ma'am.
If you have questions regarding the how or the why, or need more fullness to that explanation regarding that possibility, please make sure you speak to your attorney and she'll explain it to you in greater detail. Now that's as it relates to counts 1 and 2. Count 3, child abuse 4th degree, and count 4, domestic violence misdemeanors, both, are going to be set for a pretrial before Judge Garrett. What date?
August 18th at 9 a.m.
August 18th at 9 a.m. Ms. Tulatz, I need your signature on this order of dismissal as it relates to the felonies, as you were the moving party. And I'm going to hand that up to Madam Clerk in just a moment. Sir, you can have a seat in the hallway, okay?
Your Honor, one further thing, my client is on a tether, and I would ask that the tether be removed at this time.
Mr. Prosecutor.
Given that the complaining witness has not appeared today on the felony counts, the people would not object to the removal of the tether so long as that no contact order stays in place.
Okay, so do you understand? I will add that language that the GPS tether shall be removed, but you are not to have any contact with the complaining witness.
Ma'am, I know.
Okay, good. All right, we're all set. Again, that pretrial date for the misdemeanors is August 18th.
Okay.
Okay? And I'm not sure if you're going to represent him. I don't know if you're retained or not, but misdemeanor defender's office is available for those court dates.
Okay, Your Honor, I was appointed on the felony, so he will need another appointment to come on this.
This is for Ms. Tulatz. Okay, we're all set.
Calling parties, you can exit, sir. Let him
Oh,
go
can you have that
back.
back? I'm sorry. Ms. Tulatz, I need that back, sorry. I need to put the information about the
GPS
GPS.
tether. Yeah. Calling parties on Dunson. Case number 2061904, the people of the state of Michigan versus Gregory Dunson. The defendant is charged with count 1 and 2, assault with a dangerous weapon, felonious assault. This was scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service of Detroit, by Nancy Richards, P68850, appearing on behalf of Mr. Johnson, who is present and standing to my right.
Thank you. Could you please state your name?
Gregory Dunson.
Thank you. Today is the date and time set for preliminary examination. Are we proceeding to an exam?
Your Honor, at this time, the complaining witnesses Chantel Lee and Darnell Jones are not present in the courthouse. They were subpoenaed to be here for an 11:30 a.m. preliminary exam. Without their presence and participation, people are unable to go forward at this time on any count.
Is there a motion?
Defense moves to dismiss.
That motion is granted. I think you were standing in here when I gave the explanation to the gentleman before you, but I'm going to explain it again on the record, that I'm dismissing it, but it's dismissed without prejudice. And what that means, Mr. Dunson, is that it is possible that the prosecutor can reissue in this matter. If you have questions regarding that possibility, please make sure you speak to Ms. Richards and she'll explain it to you in greater detail. Sir, do you have on a GPS tether that needs to be removed?
No.
Okay. I'm going to prepare that paperwork and you'll get a copy brought to you in the hallway, sir. Ms. Richards, once it's prepared, I will need your signature on it and we're all set.
Thank you, Your Honor.
Thank you.
Who's up next?
Robinson?
Patrick? They'll bring it out to you.
Okay. Thank you.
Yeah.
Everyone have a wonderful day.
You too.
Calling parties on Robinson.
Sorry, I just want to let you know,
Yes. Okay.
since we're obviously running out of time, even the adjournment on Hussein is going to go in a second because we have the two interpreters. So I just, that'll take a few minutes.
So we finally did get the two interpreters?
We did.
Okay, thank you. Okay.
Calling parties on Robinson, case number 2056395. The people of the state of Michigan versus Patrick Dwayne Robinson. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3 and 4, weapons, felony firearm. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Lynn Bailey on behalf of the people, P84009.
Morning, I'm Jeff Coleman on behalf of Mr. Robinson, P80517.
Thank you. Please state your name.
Patrick Robinson.
Thank you. Today is the date and time set for preliminary examination. Are we proceeding to an exam?
Your Honor, I spoke with my officer in charge who indicated that the complaining witness was unable to be here today, and that she was available via Zoom. However, as this was not scheduled for a Zoom exam and the defense has not consented to such, the people will be unprepared for today's proceeding.
We would move to dismiss this matter.
Okay. And tell me again why it is that the complaining witness did not appear?
Your Honor, from what the officer in charge told me was that she was unable to leave her business to be here in person.
Was she notified of today's court date?
Yes, ma'am.
Anything further?
No, Your Honor.
Okay, in order for me to, and you're requesting what?
At this point, Your Honor, I'm not requesting anything.
Okay, I just wanted to be clear because there has been a motion to dismiss and I just wanted to know if I needed to respond to a request you're making at all. Because what I was going to say is that if there is a request to adjourn, but there isn't, I was going to say I would need to find good cause, and what I've heard thus far doesn't amount to good cause. But there is no request on the floor to adjourn, so I am going to grant defense counsel's motion to dismiss. The matter is dismissed without prejudice, which means you've been in here for a couple of these cases, so you probably heard me say this. It is very possible that the prosecutor can go back to her office and reissue before the ink even dries. Okay, the prosecutor's office has that discretion whenever a matter is dismissed without prejudice, as is the case here. So, just if you have questions regarding that, please make sure you speak with your attorney and he will explain it to you in greater detail. But as for now, the matter is dismissed without prejudice. Do you have on a GPS tether that needs to be removed?
No, ma'am.
Okay, paperwork will be forwarded to you in the hallway in just a moment, and council, I'll need your signature on the order once I prepare it.
Thank you.
Thank you.
Do you know did you want to address the date on,
Yes.
yesterday? Is the prosecutor available?
Should respond to the email?
I haven't been on email, so I don't know.
Is it Pete?
Lewis.
Oh, who's the prosecutor?
Yeah, he.
Oh,
This is the matter yesterday, from yesterday, Judge.
I'm just looking to see if she's in the waiting room, and I don't have anyone.
She did indicate that they would work for her.
It all has to be, it doesn't matter what's good for her, though, we have to make sure. So, I mean, if you want to try to zoom back in tomorrow morning,
Okay, what's the latest you'll be on the record today?
in about 10 minutes,
Okay,
12:30,
I'll
we
do
shut down at 12:30.
tomorrow morning. Thank you.
The two of you had talked and discussed a date that's closer?
Yes.
Okay, all right, so just if you could zoom in and we'll.
I'll
make
go
sure
back
that you-
in and I'll check it and make sure, I don't have time, I didn't have time to read any emails.
Sure, I understand.
So
Thank you.
calling parties on
Thank you,
Lewis,
counsel.
case number 21-56561, the people of the state of Michigan versus Lennon Eugene Lewis. The defendant is
Ms.
charged.
Perlman, don't forget I need your signature.
Oh, yeah, the defendant is charged with count 1, weapons carrying concealed, habitual offender, second offense notice. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Brenda Bailey on behalf of the people, P84009.
Good afternoon, Judge Patrick Nyhuis, P76343, on behalf of Mr. Lewis, who's present in the courtroom. Thank you.
Mr. Lewis, please state your name.
Lennon Eugene Lewis Jr.
Thank you. Today is the date and time set for a preliminary examination. This was set for 10:30, it's currently 12:18. Are we proceeding, or was the desire to still hold an exam?
The desire was to still hold an exam.
Okay, obviously, we are, with any non-custodial matter, there's always the risk, given the overflow from the pandemic, that we will not be able to accommodate each and every examination. Today was one of those days where we started off really slow with nothing really happening at the top of the morning, and then everything came crashing in. And there's just no physical way to accommodate every single hold, unfortunately. We also, it should be noted, have to do a hard stop at 12:30 due to union requirements, so that everyone can take a bathroom break, get some sustenance, and just step away for a moment. It's something that we have to do, and this court does oblige to those requirements. That means we need to get a new date. So, Madam Clerk, if you could let us know when is a good rescheduled date. Were there witnesses present?
Yes, Your Honor.
How many?
One
And is it an officer witness or a civilian?
officer witness, Your Honor.
Okay. Or is that officer in here?
No, I will go
Thank
get
you.
the officer.
We want to make sure we don't conflict with any furlough.
Judge, on an unrelated matter, can I talk
About
about a case that could be up tomorrow?
Okay.
Mr. Perlman, I have your email here. I didn't even have time to.
Oh, okay.
I don't know, what do you want to do on it?
I'll just make sure he's brought over.
Oh, okay. I mean, that's what we always shoot for.
Yeah, yeah, he just,
We just don't have control over that.
he has a personal bond, so I didn't know if you knew he was locked up.
I'll do it this afternoon.
Okay, thank you so much. I wrote it down here too, because I wasn't sure, I first got if I sent you that email or not.
Okay, the officer is now in the courtroom. Can we find a new date?
All right.
And Judge, I wanted to state that I apologize for, this was already adjourned one time because I had a family emergency. It was Bailey, that's correctly?
I am Miss Bailey, yes.
Yes, and, she was here, and I think the witnesses might have been here as well, but I had to take my daughter to the ER, so.
No, November 16th at 10 a.m.
Officer, November 16th.
Yes, ma'am.
Do you have any furlough at that time?
No, ma'am.
Ms. Elias?
No, it works for the defense, Judge, thank you.
The new exam date is going to be November 16th at, tell me again, did you say 10?
Yes.
At 10 a.m. Thank you, officer.
Thank you.
Thank you very much.
Thank you,
Judge.
Your Honor.
Thank you, and I'm gonna mute this for a second.
Back or Miss Mitchell.
Miss, I don't see her anymore. Miss Jefferson, did you speak with your client on Zoom?
I did, Your Honor, and I want to thank the court again for that time. Your Honor, I apologize for not being there, not writing it down properly. I am respectfully asking the court for an adjournment.
Oh. Okay. All right, can we bring that gentleman back in? Bowen? Yes.
And Your Honor, this is Attorney Mitchell. I'm here on Whitfield.
Yeah, she's wanting to enter in a waiver on that. We got like a million things going.
Hi. So let's do one of the two ones first. I don't see Mr. Bowen in here, so Whitfield is ready.
Okay. Calling parties on Whitfield. Case number 2157439. The people of the state of Michigan versus Andre Whitfield. The defendant is charged with count 1 weapons, carrying concealed. Judge, this matter is scheduled for a preliminary exam in November, but they would like to enter into a waiver today.
Thank you. Appearances, please.
That's you. It's a carrying concealed.
Bryn Bailey on behalf of the people, P84009.
I'm sorry.
Good afternoon, may it please this most honorable court. Rena Mitchell appearing on behalf of Mr. Andre Whitfield, who's appearing by Zoom. Mr. Whitfield, I need you to unmute and state your name for the record.
Andre Whitfield.
Thank you. What's your pleasure here?
Your Honor, we would like to waive the preliminary examination and be bound over to circuit court on the charges.
Any objection?
No, Your Honor.
Okay, Mr. Whitfield, do you understand the allegations against you, sir?
Yes, ma'am, I do.
Do you understand that you have a right to a preliminary examination?
Yes, I understand.
Do you understand that if an examination were to occur, that the prosecutor would establish by a probable cause standard only that crime was committed in the city of Detroit, County of Wayne, and that you probably committed that crime? Yes or no?
Yes.
Okay, do you understand that if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings? Do you understand that?
Yes, ma'am.
With the representation that's been made here today that you wish to waive your right to an examination, do you understand that that would mean the matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam?
Yes, ma'am.
Is that how you wish to proceed today? And is that how you wish to proceed today?
Yes, it is.
Are you doing so voluntarily?
Yes.
Thank you. I do have the examination waiver form returned to the file, which appears to be properly executed. I do find your waiver to be knowingly and voluntarily given. The matter is now bound over to the circuit court for further proceedings with an AOI date of August 25th, 2021. Is there anything further?
Nothing further. Thank you so much.
Thank you.
Okay.
Mr. Bowen? Mr. Bowen?
Mr. Bowen.
Okay, recalling People versus Bowen. Brandon Bowen, 200617000. Appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Your Honor. Thomas Jefferson on behalf of Mr. Bowen, P42872, and Mr. Bowen is present.
Okay, please state your name.
State your name for the record, please.
Brandon Bowen.
Your Honor, on behalf of Mr. Bowen, I respectfully apologize to the court once again for not being there. I somehow I guess wrote the date in the wrong place when I was last there. However, Mr. Bowen we are asking for an adjournment, Your Honor. He does want to have in-person exam.
Judge, November 19th at 10 a.m.
November 19th at 10 a.m. Does that work?
Yes, Your Honor.
Okay, so now here's the thing. Mr. Bowen, thank you for being in place. Ms. Jefferson, we need you to make sure you mark your calendar.
I put it in there right now, Judge.
All right, November 19th at 10 a.m. is going to be the in-person examination, so we'll need you back, sir, just as you were here today. And make sure that you allow enough time to pass through that screening so that you're here in the court on time, okay?
Okay.
All right.
November 19th.
November 19th at 10.
Okay, will I get any notification or just remember?
Well, we send out an email.
I'll send him a notification.
Because I came early today because I didn't get a time last time.
I'll send you a notification.
All right, we're all set. Your attorney will be in contact with you, sir.
Okay.
That's right. Thank you. Thank you, Your Honor. Thank you so much. And again, I apologize.
So is Mr. Bloomers in here? Is Mr. Bloomers in the hallway?
I'm sorry, I couldn't hear you.
I need Mr. Bloomers.
Mr. Brewers?
Yeah. Yep, you can hand it to him and he'll bring it to you. It is a BB case, right? You're not on Hussein, are you, Miss Bailey?
No, ma'am, that is Mr. Bloomers.
That's what I thought. Is there two interpreters?
Yes.
Can you ask the other interpreter? 'Cause she'll need to.
Okay.
Judge, I just want to say, how are you?
Good, how are you? Good to see you.
Good,
It's
good
been
to
a long
see you.
time.
Yeah. How's your family? Everything doing good?
Really good, thank you. Everything's good. And you? You're doing well?
Can't complain, and like,
Good.
very busy in Zoom,
Yes, I can imagine.
Is he on Zoom?
He might be speaking with the complaining witness if she, or the interpreter.
Oh, okay. Calling parties on Hussein. Case number 2157868, the people of the state of Michigan versus Soror Hussein. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Attorney Ben Werling, P64889, on behalf of Mr. Hussein.
And your
Judge,
name?
good afternoon. I examined the interpreter for Mr. Hussein Saror.
Okay, and I know we have another interpreter.
I'm Dean Limon, I'm the interpreter for. I'm the interpreter for Deepak Khanna.
Okay, and do you have cards? Both interpreters, before I swear you in, I wanted to tender cards with your name on it so that we get the correct spelling so that I can give it to Madam Court Reporter, if you have it.
I can make a copy of the paperwork, I guess, Judge.
Oh, okay.
And give it to the court.
You want me to just hand that to her now?
No, sure. I'll just make her a copy.
Okay, sir, could I trouble you to state your name again?
Sayed Simon.
Thank you. Please raise your right hand. Please solemnly swear or affirm to translate accurately and properly from English to Bengali, Bengali back to English.
Yes, I do.
Thank you. And sir, could you please state your name again?
I'm Dean Limon.
Okay, and do you solemnly swear or affirm to translate accurately and properly from English to Bengali, Bengali back to English? Thank you so much. Could you please state your name?
Soror Hussein.
Thank you. And We are set for an examination here today, correct?
Yes,
Yes, Your Honor.
However, it is currently 12:30 and the court has to close down at this time for lunch. We try to fit in as much as we can every day, but unfortunately, we are not going to be able to fit in this matter. Unfortunately, we're not going to be able to fit in this matter as we've been on the record all morning trying to accommodate the fullness of the docket. The record should reflect that the defendant is not in custody. And I stress that only to the extent that our priority is to handle custodial matters first. And today we were jam-packed with plenty of non-custodial matters. With this case involving not only an examination that needs to be held, but interpreters that are going to be required and are present. Thank you so much for being here. We do need to find a new date. Madam Clerk, what date can we find that might make sense for such a, how many proposed witnesses?
Just the one, Judge, but I would, I guess, propose something earlier in the morning, just because it will move slower, even though it is just the one witness with the two interpreters and everything.
I'm cautious to the extent that I don't want to make it too close because we are really jam-packed. So it's not going to be right around the corner. Are there any concerns you have, Mr. Bloomers, about the bond that might make us bring that date closer?
No, Judge, not at this time. The defendant is on a personal bond with a GPS tether.
Judge, October 19th at 10 a.m.
10 a.m.
Does that date work for you?
That works for the defense, Your Honor.
Okay, in-person examination.
October 19th, Judge, right?
October 19th, yes, at 10 a.m.
So I'll just change it, October 19th, okay?
Is there anything further?
I'll get you up.
No, Your Honor. I just confirmed with the planning witness that date will work. So,
Okay.
And so if I can have it again, I'm sorry. Thank you, Judge.
Okay, thank you.
It was October 19th at what time?
October
10?
19th at 10.
At 10.
Thank you. Thank you, Judge.
Thank you. We're all set here. The court is going to stand in recess until 1:35.
Thank you, Your Honor.
Thank you.
Although,
Sure.
honestly, we need it to go to January.
I know.
I know because
At that time.
I've been trying to squeeze in, but
Yeah.
as we get there, we're gonna be squeezing more in.
Yeah,
and it's
yeah, that's
just so-
true.
It's just not even. So I think tomorrow, I was just trying to get through July, so we
Yeah.
did good.
Yeah, I think so.
So tomorrow, the dates I give for our custody, I'm gonna start in January.
Yep. I hear you.
It's just, cause it's like today, there's just too much.
Okay.
Hey, sir, I'm not sure what case you're on, but the court is down to 135.
Okay.
Do you have a matter? Okay, your attorney is probably gonna come call back in on you. We're down until 135, Mr. Strong.
Okay, we'll zoom back in at 1:35.
Oh, yeah, Strong.
All right, thanks, Tammy.
All right, bye.
All right, 1:35, sir.
Mr. Pratt, what kind of matter did you have?
That's Mr.
Okay.
Christian. That's Mr. Christian, Tammy.
Okay, all right, we'll see you back at 135.
Okay.
All right, bye.
Oops, now your audio.
Nigga ugly as hell, man.
Where they at? They ain't even in there.
Were you talking about me?
No.
I just want to let you know, we can hear you, so you guys might want to mute your phone until we come back up into session, because we can hear what y'all are saying.
Okay, I'm sorry. I think I was talking.
That's okay. I'm just messing with you. I'm gonna mute you guys.
I muted myself. Hello? Hello? Excuse me, this the court for Judge Archer, right?
Yes, it is. Just a moment. Mr. Strong, are you available? I don't know that we have a,
I'm here.
prosecutor judge. Okay. I don't know if, unless Mr. Makepeace is gonna stand in, I don't know that we're gonna have a prosecutor. Yeah, so.
We'll figure it out. We're gonna call the case that we've got in the courtroom right now, and if we can get a stand-in.
Sure.
I don't know if it's a deep. I mean, I'm not sure that, if you talked to Tammy about it, I don't know.
No, I didn't.
I have no
So
idea.
we're gonna start with this case, and we're gonna put a quick message out to the prosecutor and see if they can zoom in.
Okay.
If they can, we're gonna let you know something as soon as we can, Mr. Strong. But we're gonna pick up with this case. If you wanna call Tammy, 965-2282. We're gonna start this exam. We're trying to get the prosecutor that corresponds with your case to zoom in. But in the meantime, we're going to start this exam, okay?
Calling party Kegler, case number 2157010. The people of the state of Michigan versus Elijah Kegler. The defendant is charged with count 1, homicide, manslaughter, involuntary, count 2, 3, and 4, child abuse, second degree. This matter is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Your Honor. Matthew Makepeace on behalf of the people, P82796.
Good afternoon, Danielle Cabaret, P77162, on behalf of Elijah Kegler.
Your name, sir?
Elijah Kegler.
Okay. Are there any preliminary matters that we need to tend to before we begin?
Yes, Judge, people would ask for a mutual order of sequestration for all witnesses in this case and ask for an exception to the officer in charge, Detective Doug Williams. I'm the in court.
So, is there any objection?
No.
Good afternoon, Detective Williams. There will be an exception made for Detective Williams. Otherwise, the courtroom is already restricted as the court is still complying with COVID restrictions that are in place. So there are no spectators in the courtroom. The only individuals that are present in the courtroom are those that are involved with this immediate case, those working the courtroom as well. I am going to, however, restrict the Zoom gallery. Mr. Willie Clark, I know why you're here. When we're ready to call your case, I'm going to bring you in but for now, you're going to be put into a waiting room, okay? Breezy, can you identify yourself, please?
Brianne Wells.
And what are you here for today?
The Otis Coyle case and Daryl Johnson.
Oh, now that name sounds familiar.
Judge, if I may speak.
Yes.
Ms. Williams, I believe that case is in Third Circuit Court. You need to go to the Third Circuit Court website to docket C.
Okay, I don't know how to do that. Okay, I have to figure it out.
Yeah, I spoke with Otis Coyle Sr. this morning, and if you can talk to him, he'll have the information.
Okay, you said it's in Third Circuit Court?
Third Circuit Court, yes.
And docket C. Okay, thank you.
Okay, Christian Pratt, can you explain what you're here for? Oh,
I'm here with Ronnie Strong. They said they locate my prosecutor.
okay, great. I'm gonna put you in a waiting room, okay?
All right.
Thank you. All right, otherwise the Zoom gallery has been restricted to just those that are working the courtroom. The third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream, they shouldn't be watching because you're either a witness or a potential witness. Now would be the time to stop from watching these proceedings to maintain the integrity of this process. That being said, are there any other preliminary matters, Mr. Makepeace or Ms. Catteray?
Yes, Judge, I do have one more. I would move for the admission of People's Proposed Exhibit 1, which is the medical examiner's report associated with this case. And that was MCL 766.11B.
And I'm assuming you've had an opportunity to review that as well, Ms. Catteray?
Well, I'd like to show you the document to make sure that it's the same one that I have.
Okay.
So I do have some objections to what's in this report, and they would be surrounding the summary of what occurred, because it's filled with a lot of inaccuracies, and I don't want the court to rely on those statements.
Judge, if I could get a more accurate description of what pages and what portions of the report I could respond.
Sure.
Definitely that third one has to be. I can't see like 2 feet away, and I can't see that good enough. Maybe I have to have it closer.
Mr. Makepeace, could you share this with Ms. Catteray?
Yes, Judge.
Oh,
Yes.
prior to today?
Yes, Judge.
Oh,
He did share it with me, but I did not know that he was gonna just move to admit it, Judge.
is it, this, count one is a homicide, correct?
Yes, manslaughter.
So, I mean, he wasn't,
Typically,
he wasn't on the
medical-
page, so I guess he maybe could have talked to me too, prior to see if I had an objection.
Well, he's moving for its admission under the court rule, correct?
Yes, Judge.
As a matter of courtesy, I was just asking if you'd had an opportunity to peruse it. I didn't realize there was going to be an objection.
So the prosecutor also has a responsibility to make sure that the record is not filled with inaccuracies. So I guess I relied on him making sure that that wouldn't be in here. So it's the last few pages. There's 1, 2, and 3 pages. 1 of 3, 2 of 3, and 3 of 3.
And Judge, with respect to those pages, it appears to be a document titled the Case Registration Summary, which is a standard portion of any medical examiner's report. It summarizes what was the information given to the medical examiner's office from the hospital. I guess my response is, Judge, regardless of what's in here, it was information given to the ME's office. It's included in their report. It's a standard portion of the report. I believe it is admissible under the court rule.
Did you care to respond?
Yeah, it's inaccurate. The prosecutor has a responsibility. It doesn't matter what's in the court rule. The court rule is, I guess, taking it as the assumption that everything in there is accurate, and this is inaccurate.
Yes?
Very briefly, Judge, I mean, what is in here? I mean, there's no evidence on this record to show that it's inaccurate right now. Ms. Catteray is saying that it's inaccurate based on her review of the discovery, I'm presuming. But at this point on this record, this is being offered for admission. There's no other evidence being offered at this time until the testimony comes in. And with respect to my responsibility, I also have a responsibility to prove my case to a probable cause standard at this point. I believe this document starts me on my way for doing that. I don't want to remove something from the document because I also have a duty of candor to this court to admit evidence, admit complete evidence when, Ms. Catteray is basically saying, I have to make sure everything's accurate, but I also have to then remove information for this court's consideration. I think any inaccuracies, Ms. Catteray is free to argue when we get to the bind over portion argument of this hearing.
People's proposed exhibit number 1 is going to be admitted as people's exhibit number 1 over counsel's objection. The objection is noted. And is there anything else?
People have no other preliminary matters, Judge.
Ms. Catteray?
Yes, I do. I want to put on the record that the officer in charge here went to my client's house yesterday and was sitting outside of there for several hours and was apparently yelling outside, I guess trying to embarrass them from their neighbors, and stated, quote, I tried to help you guys out if you would have just came and talked to me about this case of your son grabbing a gun and shooting himself in the head. So it appears that this officer in charge made a statement that my client's right to remain silent should have been waived in order for my client to have not been charged with this case. Second, besides that, I've gotten 2 copies of the Kids Talk video from the prosecutor, and neither one of them, the audio works. So I need to be provided those videos in some format where the audio works or figure out what the problem is, because I've tried them on several computers.
Okay, so my response to number 1 is, what is the relief you're seeking? Are you asking for Detective Williams to exit the courtroom, or did you just?
Yeah, I'm putting it on the record. I need to research the law on that. There may be a forthcoming motion since Friday is the another day set for this exam.
Okay. Well, you're now put on notice as it relates to some possibility that the defense may be filing a motion in that regard. As to the second issue you raised, Mr. Makepeace, did Ms. Catteray indicate to you she was having problems listening to the audio portion, which I would imagine is quite significant?
Yes, Judge, they're witnesses, they're children, but they're witnesses' statements. It is very significant. However, Judge, today is the first time, so if I could just go back, there was discovery issues with evidence.com originally. Because of those issues, Ms. Cadaret and I worked together. She dropped off a external hard drive at my office, which I placed all of the evidence on, including the kids' talks. And I believe that was dropped off on July 9th, 2021, and returned to her the same day, about 30 or 40 minutes later, after all the evidence was placed, all the discovery was placed on there. Today, August 4th, is the first time I'm hearing of any issues with the kids' talks. I told Ms. Cadaret if she had any issues, that she should call me, we can figure them out. You know, these kids' talks do come in a very odd and I would say old computer program that doesn't always work. But there was several options that we had I been given some notice. I'm more than happy to work with Ms. Cadaret to get the kids' talks in a workable format. I can screen record the entire kids' talk, provide them in a different format. There's a lot of things that could have been done had I been given some notice on this issue.
Okay, so then, it begs the question again, as it relates to the concerns you raised, what relief are you seeking from the court?
I'm just asking for him to provide that. I don't believe he's gonna use that today. So, I think that if he can provide that before Friday, that we can make that work.
Mr. Makepeace?
That's fine, Judge, I have no problem with that.
Okay, thank you. Anything else in a preliminary form?
No.
And to be clear, there was an exception made for Detective Williams, but I wasn't certain. Are you asking for him to exit the courtroom now?
No, I'm asking for him to, not violate my client's constitutional rights, or if that was the reason why he, made that, or pursued this case, that, you know, I take exception to that, and that I don't want him doing that again. He does not need to be stalking my client outside of his home.
Judge, if I may just respond as to why Detective Williams was at the home of the defendant. It's because this is a situation that happened within a family home where the defendant, his wife, and children were living at the time. And his children, the defendant's children, as well as his nieces and nephews who were also living in the home, are all witnesses. Detective Williams was at the location where witnesses were living to serve them with subpoenas. For the record, they refused service of those subpoenas, and he left the subpoenas in the mailbox, I believe, if I'm correct. He's nodding his head yes. And that's why he was at the home. He was not stalking the defendant. He was attempting to do his job in serving subpoenas to material witnesses in this criminal case.
You know, that's inaccurate. The subpoenas that the officer brought, I believe there was just one, and it was not to, Mr. Kegler's family. It may have been to, his niece, but his niece does not live at that address. And when you talk about Mr. Kegler's children, his son was not even 2 years old, so I don't know if they need him to testify.
Judge, the subpoena was for the defendant's wife, who has custody of the children that were in the home, some of the children that were in the home. That child, I believe, is Miriam Quelly, is the victim or the witness's name that he was there to serve, who was kid stalked in this case.
Okay, well, if the purpose was to serve subpoenas, I'm certainly not going to thwart Detective Williams in the event there's a need to do so in the future. And the concerns are noted. If there's nothing else in a preliminary fashion, can you please call your first witness?
Yes, Judge, just one correction.
Was there something else?
No, I mean, I guess I just put on the record that there may be some outstanding body cams where I will talk to Mr. Makepeace about those after.
Oh, and before you call the first witness, were you going to read into the record the cause and manner?
I was going to do that, and I just need to make one correction. I misstated the child's name that Detective Williams was there to serve. It's Tamara.
Okay, thank you.
And if I may at this time, Judge, summarize the medical examiner's report in Exhibit 1.
Please do.
This is the medical examiner's report in ME case number 20-18342, County of Death Wayne, Town of Death Dearborn. Not sure why it says that, and that's what it says though. Date pronounced dead December 17th, 2020. States this is to certify Omar Reyes, medical doctor, assistant medical examiner at the Wayne County Medical Examiner's Office, performed a post-mortem examination on the body of Taman Quelly on December 18th, 2020. In the summary and opinion section, the first line states, "It is my opinion that death was caused by gunshot wound to the head." States that the manner of death is suicide.
Thank you. Could you please call your first witness?
Yes, Judge, at this time, the people call evidence technician Anthony Johnson.
I believe this is Hicks. Oh, I'll just put that. The motions. Good afternoon to you, sir. Could you please come forward to the podium and state your name and spell your first and last name, sir?
Anthony Johnson, ANTHONYJOHNSON.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth, sir?
I do.
Thank you. You can make your way over here to where this half gate opens up towards you and have a seat. Mr. Makepeace, once he's settled, you may proceed.
Thank you, Judge. Sir, could you state your full name for the record one more time?
Anthony Johnson.
Are you currently employed?
Yes,
How are you employed?
evidence technician, Detroit Police,
And how long have you been an evidence technician with the Detroit Police?
approximately 20 years.
And did you work for another police department prior to working with the Detroit Police?
No,
Okay, so you all 20 years at the Detroit Police Department?
yes, sir.
And have you been in evidence tech for that entire time?
Yes.
Okay. I want to take your attention back. Well, let's do this first. What are some of your roles and responsibilities as an evidence technician for the Detroit Police Department?
We respond to scenes, document the scenes via photographs, collect and process any evidence that the officer in charge has requested.
Okay. And when you say document the scene via photographs, what do you use to take that photograph?
A digital camera.
Okay. And collecting evidence, does that mean physically picking up evidence and placing it on evidence?
Correct.
And can you describe the process of placing something on evidence?
We identify the evidence, something here has evidentiary value. Then we collect it, always wearing gloves, collect it, place it in a bag or an envelope, transport it to the area that where we're going to process it. Most of the time, that's at our base, crime scene services base, or directly to the secured property room at Detroit Police Headquarters.
Okay, and when you collect a piece of evidence and place it in a bag or whatever you preserve it with, do you assign it an evidence number?
Yes.
And is each piece of evidence signed a unique number?
Yes.
Okay. And how are the photographs stored and saved if they are?
They're stripped. We load them or transfer them from the camera to a computer and then to a database.
Okay. And are those photographs labeled by a specific case number as well?
Yes, they are.
Okay. I want to take your attention back to December 17th of 2020. Were you asked to go to a scene at the location of, I believe it's 8327 Penrod?
Yes.
And is that location in the city of Detroit, Wayne County?
Yes, it is.
Why were you asked to go to that scene?
I received a run from dispatch that, someone had been shot.
Did you receive any other information?
No, not until I got there.
And when you got to that location, did you take photographs?
Yes.
And did you collect physical evidence as well?
I'm gonna object to this. We can let the officer testify to what he did instead of leading questions.
I think they were primarily foundational questions, but objection sustained.
Okay, Judge. When you responded to this location on Penrod Street, is there a standard operating procedure that you follow when you get to a location to process a scene?
Yes, there is.
Tell me about that.
When I approach the scene, I contact the officers that are there, the officer in charge of the case, to determine exactly what it is that he or she wants done.
And do they normally tell you what they want done?
Yes, they do.
Okay, so when you responded to this location on Penrod, did someone tell you to do something?
Yes.
Who was that person that told you to do something?
Could I look at my report to get the name right?
Would that refresh your memory?
Yes, it would.
Then please look at your report and look back up at me.
Okay, so I'm gonna object to, I didn't see he had papers with him, that he not have any documents with him at the stand, and that the prosecutor provide the documents that I could view them first,
Certainly.
which I think is also standard procedure in an exam.
It's just his report. Judge, it's just his report, which has been provided to the defense counsel, to Ms. Catter.
Thank you, Mr. Makepeace.
So I don't believe that it was provided to me in this format. This looks like notes to me, actually.
Would you like some water? There's water behind you if you'd like some.
Oh, not right now.
Can I ask him, are these your notes? Did you type these notes?
No, that's the report. The report, we have.
Tammy, were we able to find a corresponding prosecutor?
I sent an email to Ms. Bailey unless you want me to start to.
Perhaps we should tell him to Zoom in tomorrow. Tell him nothing.
I'll call
Mr. Strong.
Well, yeah.
Mr. Strong?
Ready, Your Honor?
Hi, could I trouble you to Zoom in the morning, because I don't want to keep you hanging unnecessarily. I honor and respect your time, sir.
Okay, I'll have him zoom in first thing in the morning, Your Honor.
With your client, and was the Cody who was KPS, was he with him too?
He was, Your Honor.
Yeah, they both should zoom in so that KPS, we won't injure them though.
Yes, Your Honor.
Thank you, sir.
All right, thank you, Judge.
Corresponding attorney for the other.
This is.
Yeah, thank you.
This wasn't your note.
So, yeah, she was not injured.
No, I'll send her.
This wasn't your note. And the bottom. I didn't read every one of you.
May I have one moment, Judge?
Sure.
Judge, with respect to the papers that Evidence Tech Johnson had in his hands, it appears that substantially it is his report that was provided in discovery. I read through both documents simultaneously. There is just one additional half sentence that was in here. In the report that was, and the additional information is in the report that was provided to Ms. Cataray. There is a portion of it that states in the first paragraph of narrative, in the report that was provided to me from Mr. Evidence Tech Johnson right now, the last sentence of the first paragraph narrative states, additionally, Sergeant Wright, code
I'm going
25.
to object to him reading this hearsay into the record. I just am asking for that the prosecutor to talk to his witnesses before they testify and not allow them to bring documents up there without me seeing them, and that the prosecutor use his report instead of what the witness has brought in with him.
I think that's a fair request.
I have no problem with that, Judge.
So I think we still are at the point where he wanted to refresh his recollection. So if you could approach with the report that Ms. Cataray has a copy of as well.
Yes, Judge.
Thank you.
May I approach?
Yes. And once you've reviewed the report, if you could put it face down in front of you and then proceed with the question.
Judge, I'll take the report back when he's
Okay,
done.
thank you.
So that he has no papers. Is your memory refreshed?
Yes.
For the record, I'm taking back the report that was handed to him, which is his report that was provided to Ms. Cataray. I believe the question before you looked at the report was, did you speak to someone at the scene that told you what to do, and who was that person?
Detective Mativa and Sergeant Wright.
Okay, and do you know who they work for?
Detroit Police Department, homicide.
Thank you, sir. Now, based on the information and directive from them, when you got to the scene and started your process, what was the first thing that you did?
First thing I did was fill out my photo identifier. Then I started taking photos of the home. We start on the outside. If there's anything that needs to be pointed out on the outside, then we go ahead and photograph that. Then we move into the home to the various areas of the home that have to be photographed or evidence has to be collected from.
Okay, so fair to say, excuse me. Let me ask you this, is that the process that you just described in terms of taking photos of the scene, is that standard operating procedure that you always follow?
Yes.
So you start on the exterior and move into the interior of a home?
Yes.
Okay. The photos of the exterior that you took, was there anything that was pointed out to you or that you observed that you deemed significant and took photos of?
I'm sorry, I'm just going to object. I don't know if he's, so the witness just testified the way he usually does, and then the way that the prosecutor's question was phrased seems that it's related to this case, but I don't think that's what the officer testified to, so I just am asking for clarification for the record. Is the question referring to something that the officer did or to what his usual procedure is?
So, yeah, certainly, if you could lay a foundation that would provide clarity, that would be able to distinguish between what he normally does upon arrival at a scene and what he in fact did on this occasion.
Sure, Judge. Thanks. So let's go back to, let me ask you this question then. In the 20 years that you've been in evidence tech for the Detroit Police Department, have you received training for your job?
Yes.
And did your training and anything else instruct you to take photos at a scene nor in a certain way every time?
Yes.
Describe that, what you normally do at a scene.
Normally, when I pull up to the scene in the van, I make sure, of course, I'm at the right place. fill out the photo identifier envelope, which has the case number, the date, the OIC officer in charge, whatever the charge or crime or what I'm there for, and the time. And my name, my code, and my job title.
Okay. And after you, well, let me ask this, do you take a photo of that identifying car?
Yes.
Okay.
That's the first button.
Okay.
Always.
And that's what you're trained to do normally?
Yes, always.
Now, what were you trained to do next in terms of just taking photos?
Take a picture of the identifier, take a photo of the front of the home, take a photo of the address. And again, I've always speak to the OIC or whoever the officers are that are from, if it's a homicide, the people that are handling the case, to see what they want me to do, because I take my direction from them.
Okay. And if they tell you to take photos, how do you normally take photos of a house based on your training and experience?
Stand back and try to get the entire house in the frame, front, and then I take a photo of the address, generally a closer photo of the address.
And that would be of the exterior of the home, correct?
Correct.
And after you do that, what do you do next normally?
Then I get with whoever is in charge of the scene or who's investigating the scene, and to find out what it is that they want me to do.
And would that be with respect to photographs, further photographs taken on the outside and the interior, or just one, or just the interior?
Both.
Okay.
If there's something outside they want me to photograph, then that I haven't seen, then they let me know.
All right.
Then we proceed inside the house, and then they tell me, what it is that they want. I always take photos trying to move directionally through a home. So that's what I do. And then they tell me what evidence they want documented and or collected.
All right. So on December 17th, did you follow that specific procedure which you just very detailedly described to the court?
Yes, I did.
Okay. Was there anything, and I'm going to follow that procedure in my questioning, exterior to interior, is there anything exterior that you were told to photograph?
Yes, there was.
And what was that?
A handgun.
Could you describe that handgun?
I'm not positive. I believe it was a .40 calibers handgun, silver, black grip, no magazine.
Okay, so let's back up for a second. Did you photograph that handgun?
Yes.
And did you also physically collect that handgun and place it on evidence as you described already?
Yes.
Okay. And when you photographed or when you collected that handgun, did you look to see if it was loaded or not?
Yes.
Okay, is that standard operating procedure?
Yes.
All right. Was there a magazine, and let me ask you this before we go into this to lay a foundation. Are you familiar with handguns?
Yes, somewhat, yes.
Okay.
I'm not a handgun expert, but.
Have you collected handguns and guns in the past?
Numerous times.
All right, and are you trained to collect those items?
Yes, I am.
Okay. Are you familiar with what a magazine of a handgun is?
Yes, I am.
Okay, was there a magazine in this handgun that you collected?
No, there wasn't.
Are you familiar with there being, for lack of a better word, because I'm also not a firearms expert, one in the chamber?
Yes, I'm familiar.
What does that mean?
It means that there's a fireable bullet in the chamber of the gun.
Okay, and when you collected this handgun, did you check to see if there was one in the chamber?
Yes, I did.
Was there a fireable bullet in the chamber of the gun you collected at this location?
No, there wasn't.
Okay. And did you collect that and place it on evidence?
Pardon me?
Did you collect this firearm and place it on evidence?
Yes, I did.
All right, and where was the handgun when you observed it?
outside of the home in the snow.
Okay. This was December. What was the weather like that day?
Cold and snowy.
Was there snow on the ground?
Yes, there was.
Okay. Now, did you photograph or were you directed to do anything anything else with respect to the exterior of the home?
No, it wasn't.
At that point, did you move into the interior of the home?
Yes, I did.
Okay. What was the first thing that you photographed when moving inside?
The room that I'm in. And there was a shell casing.
Okay, and do you remember this home?
Somewhat.
Okay. You said there was a shell casing. Do you remember where in the home the shell casing was?
I'm not positive right now. It's on my report.
Okay, with looking at your report, refresh your memory?
Yes, it would.
May I approach with the evidence tech report again?
Yes.
Thank you. You could look at that and then look back up at me when your memory is refreshed. Is your memory refreshed, sir?
Yes.
May I approach, Judge?
Yes.
For the record, I retrieved the report that you used this to refresh his memory. Do you remember now where the shell casing was that you photographed?
Yes, it was on the floor on the first floor, on the first level of the home.
Okay. And I forgot to ask you this about the handgun. Are you familiar with what type of handgun it was?
I believe it was a Smith & Wesson.
What about the caliber of it?
I believe it was 40 caliber.
Okay. And the shell casing, did you photograph that?
Yes, I did.
And did you also recover it and place it on evidence?
Yes, I did.
Are you familiar or do you know what caliber the shell casing was?
I believe it was a 40 caliber shell.
And would that be consistent with the firearm that you recovered?
Yes, it was.
All right. Was there anything else of relevance in the room with the shell casing?
Pool of blood.
Let's
Suspected blood.
Thank you, sir. You've obviously testified before. So a pool of suspected blood was in the same room as the shell casing?
Yes.
And did you photograph the pool of suspected blood as well?
Yes, I did.
Did you do anything to physically recover the blood?
No.
Okay. Were you told to do anything to physically recover the blood, like swab it or anything?
I don't believe so.
Okay. Now, after you photographed those two things in that room, was there anything else in that room that you photographed?
No, not that I recall.
Okay. And after which, where did you go next? Did you take any other pictures in the home?
Yeah, I took pictures through the home and then we went upstairs to a bedroom.
Okay, and do you remember what the upstairs bedroom, as you called it, looked like?
Standard bedroom, bungalow style, disheveled.
Okay. And did you take a picture of the entire room or as much of the room as you could capture in one frame?
Yes, I did.
And did you photograph anything specific in that room?
Yes, there was a dresser with a drawer and inside the drawer was open. In the drawer, there was a magazine.
All right. And that magazine, was it filled with bullets? Let's back up to clarify, because a magazine can be a lot of things.
There was a
Hold
gun.
on, I'm sorry, hold on one second.
I'm gonna object to, I mean, there's a lot of leading questions here. I'm just asking that you let the officer testify.
Objection sustained.
Going back, tell me about the process and what you specifically photographed in the upstairs portion of this home.
I took a general photo of the room in its entirety, as much as we could frame it in one photo. I took a picture. I was instructed to photograph a nightstand with a drawer and drawer was open, and inside the drawer, there was a magazine, which I photographed and collected.
And tell me more about the magazine.
It was a magazine that fit a .40 caliber handgun.
Okay, so it was a gun magazine, correct?
Yes,
All right.
gun magazine.
And would that magazine have been consistent with the firearm that you recovered outside?
Yes.
And would that magazine have been able to fit into that firearm?
Yes.
Did you photograph anything else in that room? Of specific items, I mean?
No, not that I recall.
Okay, and did you photograph anywhere else in the home, or were you directed to do that?
No, I was not.
Okay. May I approach, Judge?
Yes.
No, there's 6 there. I'm approaching with people's proposed exhibits 2, 3, 4, 5, 6, and 7. Could you take the time to look at each of those proposed exhibits? Sure. Did you look at each one of them?
Yes, I did.
And what did I hand you? What is contained in those exhibits, sir?
Some of the photographs that I took.
You said, sorry to cut you off, you said some of the photographs. Did you take more photographs than what I've handed you?
Yes, I don't see the photo I identified.
Oh. But to your recollection, do those appear to be fairly and accurately depict the photos you took on December 17th from 8237 Penrod?
Yes.
Okay. Move to admit people's proposed exhibits 2 through 7, Judge.
Any objection? No. Will be admitted as 2 through 7.
7, thank you, Judge. And permission to publish by placing up on the screen, Judge?
Yes.
Just need a moment to log in.
Pardon?
Is this a mic?
A microphone, yeah, the.
Not this one, this one.
Oh, no.
Oh, okay.
Does it have red illumination around it?
Mhm.
No, it's not. It's a recording device, but it's not an amplifying device.
Oh.
If that makes sense.
Yes. That's very nice.
I just let you in,
Oh,
I believe, although I don't see you yet. You're joining.
it's, my computer's very slow, Judge. Judge, I apologize, just having some technical difficulties. I'm just gonna try the classic restart my computer trick.
Okay.
I'm gonna start using mine. That works.
And Mr. Johnson, I apologize for that. I'm directing your attention to the screen. Is that Exhibit 2 on the screen there?
Yes.
And is that the location you went to on December 17th?
Yes.
Is that location in the city of Detroit, Wayne County?
Yes.
Is that standard outside picture that you took?
Yes.
Okay. Moving to what's been admitted as Exhibit 3. Can you tell us what we're looking at here, sir?
Handgun.
Is that the handgun that we spoke of that you recovered?
Yes, it is.
Is there anything of note on the handgun that you can see in that photo?
Well, I can see it doesn't have a magazine in it, and it's in the snow.
Okay, is there any other things that aren't normally on a handgun that's in that photo?
No.
Moving to exhibit 4, what are we looking at here, sir?
The upstairs bedroom.
Okay, and is this the same room that you eventually recovered the magazine that we spoke about?
Yes, it is.
Okay, could you describe what, well, I'm going to go to exhibit 5. Looking at exhibit 5, sir, what are we looking at here?
We're looking at a drawer, some type of drawer cabinet with the drawer open, but it's in the upstairs bedroom.
Okay, that's the same room from exhibit 4, correct?
Yes, it is.
And is the drawer, can you observe that there's 2 drawers on that cabinet where the TV is?
Yes, I can.
Which drawer did you recover the magazine out of?
The upper drawer.
Okay, and I want to talk a little bit about the cabinet or the drawer the 2 drawers that we're talking about. How tall off the ground does those 2 drawers come to?
About 2 feet.
And can you see on the ground to the right of the drawer next to the green bottle there?
Yes.
Can you tell what's on the ground next to the green bottle?
Looks like a game controller, a video game controller.
Looking at exhibit 6, sir, what are we looking at here?
Closer shot of the drawer.
And exhibit 7, sir, what are we looking at here?
Shot of the magazine in the drawer.
And is that the magazine that you eventually recovered?
Yes, it is.
And just, I think you may have already said this, but I'm not sure. Is that a 40 cal magazine?
Yes.
Okay.
With live rounds.
What do you mean by live rounds?
Fireable bullets.
Okay. So if you had put that magazine into a gun, it would have been able to fire, assuming the rest of the gun is working?
Yes.
Okay. May I have one moment, Judge?
Yes.
Judge, I have nothing further.
Cross-examination.
Yeah. Your name, are you an officer or do you have another title?
Civilian.
I'm sorry?
Civilian.
Oh, okay. Do you remember what time you arrived at this house in Federal?
No, I don't.
Would it be in your report?
Yes.
I showed your report to you. Would it refresh your recollection?
Yes.
I need yours.
You using this?
No, it's the one you gave him. This is may I approach? Yes. For the record, I'm handing Mr. Johnson a copy of his report. Just let me know when you're done refreshing your recollection.
Of the time I arrived,
Yes.
I'm done.
Okay. May I collect? Mr. Johnson, now that you've refreshed your recollection, do you remember what time you arrived at the house on Penrod?
Around 11:30 a.m.
Are you aware of the time that the initial call came through?
No.
When you arrived there, there were several police officers there, correct?
There were some police officers there, correct?
Would you say at least a dozen officers there?
I don't recall.
Do you recall how many were outside?
I don't recall.
Would you say it was more than a few, more than 3 or 4?
I know it was at least 2.
And then in the inside, can you recall how many officers were inside there?
No, I don't.
Would it be more than 4 or 5?
I don't recall. I know there were at least 2.
On the, so 2 on the outside, at least 2 on the outside and at least 2 on the inside, right?
Yeah, I'm referring to the same 2.
Oh, okay.
Proceeding from the outside to the inside.
Okay. Who are these 2 that you recall?
Detective Mativa and Sergeant Wright.
Okay. Can you spell Mativa?
Metiba, I believe.
Okay. And then is it Sergeant or Detective Wright?
I believe it's Sergeant.
That's W-R-I-T-H-T?
I believe so.
That's a female, right?
I believe it is.
When you were directed to take the photographs upstairs, it was of your impression that somebody had already been upstairs, right? One of the officers, you specify that.
Yes.
Were you given a list of how many officers had gone upstairs prior to your arrival?
No.
Can I ask for a break so my client can go to the bathroom?
We'll stand in recess for 5 minutes.
Thank you.
So, when COVID happened, everybody was normally I smoke, and they tell me, so I quit smoking, I was gaining 40 pounds. So I'm losing that 40 pounds. Starting to fit back into my old clothes again. I feel so much better. I'm going on vacation out of the month, so it was like I have to lose this weight. I'm not going to Jamaica with a big flappy. Everything. You're welcome. Thank you. Thank you. I'm sorry. I know, it's, I was like, wait a minute, yeah. But yeah, I mean, that's not a problem though, if they're too big, it's when they're too small. It's nice, isn't it?
Yeah, I was upset about it. I gained 40 pounds just from eating a lot of Jolly Ranchers. Who thought you could gain 40 pounds from that? Yeah, it's so easy. So easy.
Especially when you get to a certain age. I don't know what age you do.
I'm only 21.
Yeah, see,
Tammy,
it's easy for you.
Tammy, did you hear that?
I did.
I'm only 21.
Great.
Thank you.
No, just the first and last line on this first page.
Yeah. Thank you.
Judge Archer's courtroom. Hey, so what are we doing? I know, but. Oh, okay. Okay.
Okay, we're back on the record. Would you like to continue?
Yes, thank you. You stated that when you recovered the shell casing and placed it on evidence, that you believed that it was a .40 caliber, correct?
Yes,
And how did you make that determination?
by the stamp.
The stamp that's located where?
On the shell casing.
Did you take a photograph of the stamp?
I took a photograph of the shell casing. I collected the shell casing and placed it on evidence.
So you don't believe that you have a picture of the stamp, correct?
I don't recall.
I can barely hear you, I'm sorry, can you just speak up?
I don't recall.
Thank you.
Okay. Okay, I'm just going to.
When you went upstairs to the upstairs bungalow area, was there anybody with you?
One of the detectives, one of the police sergeant or detective.
Do you remember who those people are?
Yeah.
It was either, I believe it was Matiba, I'm not positive, but it was either Matiba or Wright.
So it was just one of them, correct? Or both?
I'm not positive.
Okay. Okay, so if we can get it taken care of at least before that day Friday, so by the end of the week.
So outside of that nightstand, did they have you focus on anything else in that room to take photographs of?
No.
Okay. You stated that the magazine there fit a .40 caliber handgun, correct?
I believe so, yes.
So when you say you believe so, do you know or you don't know if it would fit a .40 caliber handgun?
I didn't put the magazine in the handgun, but it was a magazine that would correspond to that type of handgun.
And how did you know that?
By looking at it.
Okay, so by looking at it, were you determining the size that you believed it would fit? Any,
Well, I've seen enough handguns and size and magazines to know, if it was an extended magazine or if it was a barrel magazine, then I know it most likely wouldn't fit that handgun. So the magazine appeared to be this type of magazine that would go with that type of handgun.
So when you testified that it was, or it would fit the .40 caliber handgun, when the prosecutor was asking, you don't know that for sure. It just appeared to you to be a magazine that would fit in a .40 caliber handgun, correct?
Correct.
When you went upstairs, initially, those drawers were both closed, correct? That black nightstand?
I don't know, I don't recall that.
Okay. I think it's exhibit 4. this one, and up to one before, that one. Yep. So this is, People's Exhibit 4, correct? Can you tell me if those drawers are opened or closed?
I can't tell.
Okay. And can you show me Exhibit 5? This is People's Exhibit 5. Can you tell if that drawer is open or closed?
Open.
Okay. And then what was the other one? So the other one that had yeah. This is People's Exhibit 7. Is this the bottom or top drawer?
I'm not positive.
Hold on a second. I just have one final question. When you were upstairs, did you or any of the one or two officers that were with you move anything in that room that you noticed?
I don't recall.
Okay, I have another question.
Can you redirect?
Yes, very good. Mr. Johnson, is it common practice for you to write the location of what you found, where it was found in your report?
Yes.
Okay, would looking at your report refresh your memory as to whether this magazine that's on the screen in Exhibit 7 refresh your memory to whether it was found in the top or bottom drawer?
Yes.
May I approach Judge with the evidence tech report?
Yes.
Please take a look at that and let me know when your memory is refreshed. Is your memory refreshed, sir?
Yes.
For the record, I'm retrieving the report from Evidence Tech Johnson. Where was that magazine found, bottom or top drawer?
Top drawer.
Okay.
Over 2 drawer cabinet.
Nothing further, Judge.
Okay, thank you. You may exit the courtroom. Your next witness.
Judge, at this time, people call police officer Gulam, Gulam, Mia.
Good afternoon.
Good afternoon.
Could you please state your full name and spell your first and last name for Madam Court Reporter here?
Yes, ma'am. First name is Gulam, it's gonna be Gulam, last name Mia, Miah.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may have a seat over here. This little gate will open up towards you. And once he's settled, you may proceed, Mr. Makepeace.
Could you say your full name for the record one more time, sir?
Yes, sir, Gulam Mia.
And are you currently employed?
Yes, sir.
How are you employed?
Employed with the City of Detroit Police Department.
Are you assigned to a specific unit, precinct, division within the Detroit Police Department?
Yes, sir.
Which one?
Homicide unit.
How long have you been with the homicide unit?
For about a year now.
And how long have you been with the Detroit Police Department in total?
5 years.
And what was your role before you were transferred or before you started your assignment in homicide?
I worked as a special operations officer at the 3rd Precinct.
Okay, and you're an officer, correct?
Yes, sir.
As part of your role in homicide, even though you're an officer, what are some of your roles and responsibilities?
Respond to homicide scenes, process the scenes, observe what's going on, and, basically in charge of the case as well.
Okay, so is it part of your roles and responsibilities to interview witnesses?
Yes, sir.
Is it part of your roles and responsibilities to interview suspects in crimes?
Yes, sir.
Okay, and are you often assigned the role of what's called an officer in charge?
Often, yes, sir.
Are you the officer in charge in this case?
No, sir.
Okay. I want to take your attention back to December 17th, 2020. Did you go to the location of 8327 Penrod, City of Detroit?
Yes, sir.
And is that in Wayne County, Michigan?
Yes, sir.
Why did you go there?
We went there because there was a.
I just want to object to the "we" testimony and to just have him testify to what he did.
Okay.
Certainly, if you could make sure, even though you were working in tandem with another officer or officers, please make sure that you keep your answers restricted to the singular.
Understood. So I went to the location because we received notification that there is a homicide scene investigation.
Okay, and if anyone, did you go there with anyone, if at all?
Yes.
Who did you go there with?
Well, I don't remember exactly who I went with, but we did go with other members from our squad.
Okay, and you say your squad, is there a?
So I just want him to, again, just a general reminder, the "we" is being referred to quite often, and I don't know who else he's talking about.
Okay, so I did go.
Just let me, well, I'll rephrase the question, but I think he was just saying we went there with other people. I think that was the point of the answer. I'll rephrase the question though. You went there, correct?
Yes, sir.
Are there other members of the homicide unit that you commonly work with?
Yes, sir.
Is that what you call and you just refer to as your squad?
Yes, sir.
And is there a leader of your squad?
Yes, sir.
Who is that person?
2 leaders.
2 leaders?
Yes, sir.
Who are they?
Sergeant Michael Dowdy and Sergeant Terrence Sims.
Okay. And is Detective Doug Williams on your squad?
Yes, sir.
Is he currently on your squad today?
Not at the moment.
Was he on your squad on December 17th?
Yes, sir.
Okay. Did Sergeant Dowdy go to the scene? If you remember.
I can't recall him.
Did Sergeant Sims go to the scene?
So I'm just going to object to the prosecutor testifying for the witness. Just ask the witness who was there or who was involved, and let the witness testify.
Well, Judge, I'm trying to avoid the "we" language by asking specific questions. I can't do both.
Please proceed, Mr. Makepeace.
Thank you, Judge. Do you remember who else from your squad went to the scene?
Yes, sir.
Who can you remember was there?
Well, I remember Detective Williams, Officer Arston, and as far as what I remember, because I was there for a brief moment.
Okay. And when you went to the scene, do you remember what time it was?
No, sir.
Was it light out, dark out?
It was light out.
Okay. And when you went to the scene, did you go inside?
Yes, sir.
Okay. Now, how long did you stay at the scene?
very brief.
Okay. After going inside, where did you go
So I'm
next?
gonna object, first of all, the leading and, also assuming facts and evidence.
Judge, the question was, where did you go next? That's not a leading question. I'm not sure what facts are assumed.
Objection overruled, he indicated he went inside. So unless I don't think I misheard that because I wrote it down. Please proceed, objection overruled.
Thank you, Judge. After you were at the scene, where did you go next, sir?
I went inside the home and I believe I was in the main living room area. Like I said, I was there for a brief moment, so as far as that goes, I just went inside the home and I was in the main living room area, I believe.
Okay. And did you go anywhere else in the home?
No.
What was the purpose of going inside the home?
It was the crime scene.
Okay. So after you were in very briefly in the home, where did you go to another location next?
Yes.
Where was that?
We went to Sinai Hospital, Sinai Grace Hospital.
What was the reason for going there?
The reason was to interview witness.
Okay. And do you see a person that you talked to that day in the courtroom today?
I'm gonna object, so we're again assuming facts and evidence, the witness has not testified to any talking to anybody. Also, he said, we went to Sinai Grace, I just really need him to discuss what he did.
Okay, so just as a reminder,
I'm sorry.
you could confine your answers to the singular. And the first part of the objection is overruled. He indicated he went to the hospital to interview witnesses. And the question, unless I heard it wrong, from Mr. Makepeace was, is there anyone in the courtroom that you spoke to there?
Right, so he went from that, the witness went there to interview people. There was no testimony that he actually interviewed anybody, and then asked him who he interviewed.
The objection is overruled. Please continue with your question, Mr. Makepeace.
Thank you, Judge. I believe the question was, do you see anybody in the courtroom today that you interviewed that day when you were at the hospital?
Yes, sir.
Could you point to him and identify a piece of clothing that he's wearing?
Yes, sir. A gentleman wearing a white shirt and black tie.
Okay, for the record, the witness has identified Elijah Kegler, the defendant in this case, Judge.
The record will reflect identification of the defendant.
Okay. And was that interview with him audio and video recorded?
It was audio video.
And how was that done? Well, let's back up here. Where did the interview take place?
It took place at Sinai Grace.
Okay.
In a room.
Are you, okay. You said in a room.
Yes, sir.
How did you audio and video record it in this room?
I was equipped with a body-worn camera.
Okay, and is that, let me ask you this, what were you wearing plainclothes, uniform, or something else that day?
Plainclothes.
Okay, do plainclothes in the Detroit Police Department normally wear body-worn cameras?
We object to relevance. You've already stated that he wore a body cam and had it recording.
Objection sustained.
Okay.
Please move on.
Thank you, Judge. Your body-worn camera, did you turn that on to record the interview?
Yes, sir.
Okay. And was the entire interview recorded with Mr. Kegler?
Yes, sir.
At this time, Judge, I move to admit People's Proposed Exhibit 8, the audio and video recording of the interview with Mr. Kegler.
Any objection? No. Will be admitted as People's Exhibit number 8.
Permission to publish to the court, Judge?
Yes.
And Judge, with respect to the audio portion of this, I do need to bring my laptop into that room outside. I, for whatever reason, can't figure it out.
Okay, thank you.
We were, once again, I'm Detective Williams, Detective Mia. We were wondering, sir, if we can have consent to search your house. Consent to search. So we got to recover the evidence. And so since it's, you all own the house, you all are occupying the house. Okay, but you live there.
Yeah.
So we have to have your consent to go in and search, to recover the evidence and take photos.
Conduct a investigation.
Whose name is on the lease?
Not ours.
Who? Okay, but you all live there.
We recently came there November 9th.
Okay.
I mean, November 11th, excuse me, November 9th, November 11th, we moved in with my sister.
Okay. So your sister is there, but you live there too. So we have to get all the adults consent. So.
Did my sister consent already?
I don't know. I'm here with you. They called me and asked me to get your consent because you all live upstairs, correct?
Yes.
So then the upstairs would be your domain. So we have to have the consent to take the photos.
Oh, yes. Okay. I thought that, yes.
Okay, so you're giving us your consent to take the photos upstairs and search?
Oh. Did he hurt himself upstairs?
We don't know.
No. That's
we
fine.
came straight here.
Yeah. Came straight here to talk to you guys.
Yes.
Okay.
Okay.
What type of legal, you say consent, what type of
So
legal matter is it?
all we're doing is for the weapon, to recover the weapon, the ammunition, and the box. I don't care what else you got up there. If it's weed or whatever, I don't care.
I'm not worried about that, I got a car.
Okay. So, once again, you give us your consent?
Yeah. Consent.
Okay. And your name is, sir? Elijah Kegler?
Yeah.
And your date of birth, sir?
5/13/1989.
5/13/1989.
Yeah.
Okay.
It should be two boxes. It should be a silver box. Like I said, I mean black and silver box. They're really small like this. They're rectangular shape.
Okay.
Yeah.
I'll start getting names.
There's a black, the black drawer, it's a small drawer, has duct tape, black duct tape on the side of it.
Okay.
They should be in my drawer where it's supposed to be at.
Yes, sir. Okay.
How did he get to my stuff?
And I'm just gonna get your name because we just got the information and we just came over here. So the deceased, that's your son. That's your son as well?
Son.
Okay, sir. Can you give me a spelling of your first name?
It's Elijah. Elijah.
And last name?
Keg.
I'm sorry?
Keg. Sorry about that.
No problem.
L-E-R.
Okay. What's your phone number?
313.
Mm-hmm.
743.
Mm-hmm.
One sec.
Yeah, no problem.
743-2761.
Mr. Kegler, what's your address over there?
Hold on, give me 1 sec, man.
Sure. No problem. I'd rather have you remember from somewhere that you have it written down.
I said we recently discussed it.
Ma'am, do you mind if I have you step out here, walk, review him real quick, and then we'll come back and interview you? Okay?
This is the address that we the house.
Okay.
Currently at
8327 Penrod.
Street. Yeah.
What's that zip over there, sir?
48228.
48238. Okay, cool. So Elijah Kevler, 51389, 313-743, 2741. I'm sorry.
2761.
27.
Let me make sure. Hold on. Let me make sure, man. Yep, 2761.
Again, we'll start off by saying condolences. Thank
you.
Okay, true. That's very important at this stage, especially victim that's over here, and that's your son. Can you give me his name, please?
Heyman. It's my middle name.
Okay, cool. Can you spell his name for me, please?
TEM. TA. TAM. I just forgot to spell my own fucking middle name. TEMAN.
And last name?
Kweli. KWELI.
Okay. Date of birth?
March 24th, 2009.
Okay.
Thank you, sir.
So, were you home when this took place?
No, I was at Henry Ford Hospital sitting in their lobby, getting ready for my appointment today. When she called me and said, screaming hysterically, said, Taman shot himself. And I just jumped up and ran and started screaming, come get me, come get me, come get me, please come get me, come get me, please come get me. Before I guess their police there see me being hysterical in the parking lot. They asked me what was going on. I told them, and they gave me a ride to their address. I tried to go in the house. I was informed I couldn't go in the house, and then my son was here, and so I ran to the car and we came here. He never said any crazy things, man. He was quiet every time we were talking. He started crying. And we kept, man. I'm like, what's wrong? Use your words, talk, man. What's going on? And he just would cry and cry. We did not know what the fuck was going on. Never.
So.
Oh my God, man.
Is that the only gun in the house?
There's my gun, yes.
Just that one?
That 40 is mine.
Okay. But that's the only one in the house?
That's the only one that I know is in that house.
That you know of?
Yeah, I brought a gun into the house. Okay. Yes.
And where do you keep that gun?
I keep my gun in it either switches. It either goes top or bottom drawer of the black small drawer. But I had it today when I was getting ready for work because I had my wallet in the same drawer as in the bottom drawer with it facing upward where I know the clip is empty. There's no clip in that gun. I shut the drawer. I duct tape it back. Now I know my lock boxes. Like I said, that's what got me so confused. I remember switching lock boxes, but I don't know if I locked it or not, man. I'm so scared. It got me so confused. I'm like, did I lock it? Did I lock it? Because I was switching. One had keys. I misplaced the keys. They were one in our book bag. So I had got a combination lock a while back from THC Detroit. They gave me a child lock box for my stuff. I put my clips and bullets inside of the gray one with the numbers on it. I was switching it over because I had misplaced my keys. And I want them. I always kept my gun empty. Always. I have children. I keep my stuff empty. I always double check. I make sure all the time. All the time. Every time I leave. Every time I go in. Every time I check. I check, man. I check. That's why I took one. I mean, so many years I could have got one. I got one. I thought I was doing so good. I waited so long to get one. I thought it was mature. I was doing everything right. I kept checking it. I made sure my gun was in there. I made sure it was empty. Even the day when I left out, I looked in that clip. It was no clip in there.
Where do you keep your clips at?
My clips were in a gray and silver container.
Okay.
I misplaced the keys in that over a gray, like a silver container with a combination on it that didn't have a key on it. You had to know the combination to get in it.
Okay.
I was switching the clips. It was over to that box.
Okay.
Over to that box. It shipped it definitely my stuff in that box. I keep all. It's not supposed to be out. It's not supposed to be like a fun. It's a fucking weapon, dog. It's not a fucking toy. It is a weapon. I keep my stuff unloaded and separated when I'm in the house with my children. It is not. I don't play that. I never wanted this in my life to happen. I've heard so. I heard so many stories of this shit, man.
So the last time you put up your gun, unloaded into that combination one. Into that combination one.
My clips and bullets are in the combination. I keep my clips and bullets in the combination. My gun stays empty inside the drawer, clip and all. I double check.
And this morning when you saw it, it was
when
empty.
I saw it, it was facing where I can see that there is no clip in my gun.
Okay.
And it was clocked back.
No, it was not cocked back. It was like no clip.
So let me ask you this question. So there was no mag in the weapon.
No.
Did you empty the chamber?
Yes, I double. That's what I'm saying. I double check, triple check. I will keep click, make sure it's empty.
Okay.
And you did all this today. When did you?
The last time I put it in the drawer. Today was rushing out to the doctor's appointment. Shut the drawer, closed it. Didn't even.
Do you remember when was the last time?
Day before yesterday. Definitely double check, and that's when I was switching my bullets and clips over to the new box.
On the 15th. Okay. Today the 17th.
Yes. Yes. Okay. I was switching it over to it was in a gray and silver, like I said, it's black with silver lining on it, and it has like a little pop lock. I misplaced the key, so I had a silver box with a combination code on it. I keep my bullets and clips, both clips. So there's two. One should be empty. One is full. And then there's bullets in there, laid around. They're in a box. And I'm sitting here going, did I put everything in that box? Did I? Cause you know. I remember.
So do you have a CPL?
No.
Okay. But you purchased that gun?
Yes, and brought it to the police, registered it.
Okay.
Paper, even the registered paper is still in the top drawer, the black drawer.
Okay.
You understand? Like.
Right.
And that's the.
Okay.
It was. Oh, this crazy shit happened to be. That's all it was. I don't walk around with that damn thing. I was so getting all these years, man. I finally got the courage to go get it.
Did you go to the house or you came straight here?
Security dropped you off.
Security took me to the house. Me being hysterical, take me to where she was at. Take me home. Me thinking he's still home at the house. When I got there, everyone running towards the door, trying to get in. He explained to me what happened. Man, I came.
Mr. Kegler, the kids that's inside the house right now, are they all your kids?
No.
How many of them is your kids in the house?
The other kids, I have 3 kids all.
When you take a moment, get the other 2 kids' name of yours.
Tamara Quayle.
Okay, may I get the spelling, please?
Tamera.
Last name Kweli?
Yes.
Okay. What's her date of birth?
July 1st. It's 2000. It's 2012, maybe even 11. Was July 1st.
How old is she?
She's 8.
Okay. And then your next child?
Tremaine. I call him Trey, so I couldn't even tell you the spelling. I would have to say my text message because then you can see that's what we call him. We call him Trey. I got all 3 of my kids there.
And his last name is Quayle too?
Sir.
What's his date of birth?
Sad to say, his birthday's tomorrow. Tomorrow, bro. That's New Year. My first go. My birthday.
What year?
Last year.
So he's 2?
Excuse me, he is 1 going on 2.
Okay.
He'll be 2 tomorrow.
So 12, 17, 19?
Yeah.
18. His birthday is the 18th.
Okay.
Tomorrow.
And then, T-Man. T-Man, is that how you say his name?
Taman.
Taman, I'm sorry.
First Testament, yeah.
Okay.
12-18.
Okay, and you said, your sister, she called you, right?
And Zane called me. My
Okay.
mother, the children called.
And when did you get to the hospital?
I arrived at the hospital at 9:55, 9:56. I sat in the parking lot until 10:06, and then I went inside.
Are you asking for this hospital or he was
No,
trying to have his treatment?
Henry Ford Hospital is
Okay.
definitely when I was at. I had my chart. I had definitely had an appointment sitting in that lobby, man. She calls me in. I can't fucking believe he never showed, other than being, never said anything.
So he wasn't depressed or anything?
He was sad. He would cry. Like, we would talk, he would cry, man. We use your words, man. You okay? What's going on?
Right.
You know what I'm saying?
Right.
What, you good? Are you okay? I even took him over his friend's house and let him stay. Even when his friend went over his dad's house and all that, I let him stay over to play the game. I did not know what was going on with him. We kept asking.
And how long ago was that?
Man, like a week, 2, 3 weeks. Like, he's been emotional. We really have. You good? Are you good? And he would start crying. And we're going, you okay? And all that other, you know what I'm saying? We're trying to see if you okay, you straight, man. He never showed any signs of that. Like I said, I'm thinking like, and it sounds, in my head, it sounds stupid because I'm like, I let you watch an anime named Blue Exorcist. I did walk in on when the dude put the gun and said, I killed myself for my family or my brother or something like that. I remember that. But, I sat there and I thought as a father, I was guiding him like, no, that's stupid. You know what I'm saying? That, you leave so many people behind. That's an ignorant ass choice, man. And I did thoroughly explain it to a Blue Exorcist. Second from last fucking episode, I walk in, I see that me and my daughter, they watching. I'm like, why did he put a gun in his head? He told me he gonna kill himself.
Right.
You know what I'm saying? And other than that, that's the only thing I can notice about him seeing anything like that. Because other than that, man, no. It's educational shows. Weekend, y'all can play y'all Nintendo Switch. Like, normal kids, he never showed any, like, he didn't show anything. He didn't show anything. Like I said, he was crying, being emotional, but...
He's not,
diagnosed with anything clinical?
We didn't know.
Okay.
See what I'm saying? We just, but that is in my family. Strong. It's in my family. My bipolar, schizophrenia, and depression is in strong, man. Grandmother, auntie, mother, my older brother, a younger sister, my help. I'm supposed to be getting checked out, bro. I don't even know. You feel me? It runs in my family, but I didn't see it in them. You feel me? I didn't see the antsiness or the, all that other stuff you would see. I have an older brother like that, and I didn't see it. I didn't see it other than them being depressed. You upset about something, man, but you gotta talk to me and let me know. Please let me know. Begging the point, man. Please. What's going on? Hugging them, man. You want to go to your friend's house? What do you want? Do you want a new game? What do you want, man, from me, dog? What? I'll do it for you. Man, you can tell me, dog, he just eat me. My son was quiet. He didn't talk. I never knew why he was like that. Like, man, talk. You good? You know what I'm saying? You kicking it with the fellas. You can. So much of an introvert, man. He just, you know what I'm saying? I was like that, so I didn't want to try to. I know how it feels to try to force somebody into being something you're not, dude. You're not going. I didn't play that. You're a tough guy, bro. I have no record, bro. I don't do that. I'm a father, and then I don't promote any ignorance in my life. I've never promoted this shit in front of my kids. Ever. Never. I don't condone that type of activity. Education first. That's what's going to get you up out of here. Nothing else going to do that for you other than an education, bro. Same thing with my daughter. This is what I promote in my house. I don't know why he would do that. I don't know why he would do that. Talk to her. I was trying to get you hang with the fellas. Open up, man. Let me know what is wrong. I want to know. I want to hang with shit with you, bro. Oh, shit. I just want to deal with you, my baby.
Mr. Coelho, just one last question. Before you left your house today, did you see Taman?
Yes.
Okay. Did you guys interact? Did he talk to you?
Yes.
You remember what you guys were talking about?
Yes, I do. Him speaking up. Use your words, man. Talk to me. I don't know what's going on with you. You're crying. You're upset. You're not talking to us, man. Use your words, man. You don't have to be like that. You don't have to bottle it up. You ain't got to, you know what I'm saying? You don't have to, you're not alone, bro. Not alone. I know he's heard me say, my dumb ass sitting here thinking, oh, I ain't got family. I ain't got me. I'm saying this shit. I didn't think my son, bro, was going to hear me. You feel me? This is what I'm going through, son. You're not going through this shit, bro. You're not going through what I'm like, I love you. You know what I'm saying? I know you love me, bro. What the fuck, though? Other than, yes, him opening up, man. You got to speak up because his brother got into some peanut butter things that were already open. I think they had threw him in the trash can. So I was like, hey, man, take me, man. You got to, you know what I'm saying? Let me know, man. He's sitting right next to you. Speak up. He started crying. And I did. I raised my voice. Man, what the fuck you crying for, man? All I said was speak up, Taman. I keep telling you speak up, man. You okay? You good? Are you good? Are you okay? Man, wipe your face off, man. You sure you okay, dog? Before I leave out and go to the hospital, are you sure you fine? You okay? Yes. He showed no signs at all. He never spoke about it, wrote about it, drew anything. I always got them drawing and coloring.
Okay.
You know what I'm saying? Just to show me. My stomach is hurting.
Yeah, I understand.
Okay, sir, we're gonna switch places and bring your wife in here and talk to her right quick, okay?
Officer, was that the complete video of your conversation with Mr. Kegler on that day?
Yes, sir.
Okay, one moment, sir.
Yes.
And officer, just a couple more questions. You said that you were in that room, correct?
Yes, sir.
Who else was in the room with you? Who other detectives?
Detective Williams.
Okay. And is he the officer in charge of this case?
Yes, sir.
Oh. And officer, are you 100% sure that it was Sinai Grace Hospital that you went to?
Judge, they asked and answered, and that's an overrule.
Okay. You can answer, sir.
I believe it was signed at Grace Hospital.
Okay. With looking at the
So I'm gonna object to that, he's not saying that he doesn't recall, so I don't know why the prosecutor is pushing his own response on the witness.
Objection, if that's an objection, is sustained.
You said you're in the homicide unit, correct?
Yes, sir.
Are you familiar with what's called a medical examiner report?
Yes, sir.
Okay, and commonly on the medical examiner's report, is there a section called the case registration summary?
Yes, sir.
And may I approach, Judge?
No, I'm gonna object to what he's approaching with, and I don't know why he just wants to just bring documents to the witness without explaining what's going on.
Judge, may we approach?
Sure. Can I trouble you to step off of the witness stand by the officer in charge for just a moment, sir?
Yes, ma'am.
Okay, Mr. Makepeace, the record should reflect that we paused for a sidebar. Mr. Makepeace was making a representation about what he was trying to do, and then Madam Defense indicated that something was inappropriate. I'm not sure if she was talking about something I did, because I didn't say anything. But let's make a record.
If I may just essentially place on the record what I just
Yes,
placed at
please, thank
sidebar.
you.
Judge, during the course of Officer Mia's testimony, he stated that it was at Sinai Grace Hospital that he had this conversation. That is inaccurate in the sense that it was actually at a Dearborn Hospital on Oakwood Boulevard. I'm simply trying to correct that fact. He, I don't believe, is purposely lying, because that would be a silly thing to lie about. I think he's just mistaken, and once he realizes that, that's what he'll say. I have an obligation as an officer of the court to correct inaccurate information that I know is inaccurate, and I'm just trying to comply with that obligation that I have under the Michigan Rules of Professional Conduct. And for the record, I was trying to impeach the witness with that information from the medical examiner's report.
That's a fairly accurate assessment. My objection is that all of that is improper. If the prosecutor wants to clarify a record, then he should ask me to stipulate, not go up to the judge and then tell you what he believes are the real facts of the case and how he gets that in. That's not appropriate. I can't come and say, let's approach the bench and let me tell you my point of view of this case. And I believe, had we not, prior to the exam starting, had this discussion about wrong information being entered in, I think that it wouldn't be as inappropriate as it was. Everything that he did just now was completely inappropriate.
So your response, that is duly noted for the record, your response to what Mr. Makepeace, well, I think that is her response. She objects to you doing that. I guess we could surmise that. Did you care to respond at all?
Can I add one more thing too?
Sure.
It also appeared that the prosecutor was asking for the judge's advice on how to get his version of the evidence in.
I don't think that he asked me, wait, I'm sorry, let me be more specific. In the sidebar, he did not ask me for my advice. So I think that needs to be very definitive. I'm not postulating. He did not ask me what he should do. As soon as he made the same representation that he just did here at the podium on the record is when Madam Defense said it was inappropriate.
Right.
We are going to proceed, and the objection is noted. We are going to proceed on to the very next question. Your answers that have been elicited by your witness have been recorded, and we're going to go forward with the next question. We're not going to, I'm not sure what you're asking for me to allow you to do right now.
Judge, I'm allowing you to, I'm asking specifically to ask.
Well, I'm sorry, perhaps now would be a proper time to ask Madam Defense if she would stipulate.
That's certainly what I was about to do. I wanted to answer your question first. I would offer a stipulation that that the hospital that Officer Mia and Detective Williams went to was actually in Dearborn, Michigan, Wayne County, and not Sinai Grace. Would Madam Defense Counsel stipulate that?
I think that Mr. Makepeace can speak to me after the exam about that, and we can discuss the inaccuracies in the medical report, a stipulation of that also. So I'm going to reserve my answer.
Okay. Certainly I would imagine you have, I don't know, but I would imagine there's another way in which you can perfect the location of that interview. We're going to move on. Is there anything further that you needed Officer Mia back in for your direct examination so we can pass him over for cross-examination?
Judge, I just have a few more questions.
Okay.
Officer Mia.
If someone could get Officer Mia, that would be great.
Did we get it by now? This is what we got.
Thank you for your indulgence, Officer Mia. We're going to continue with direct examination.
Thank you, Judge. Officer, did you do anything else in this case other than interview Mr. Kegler?
Not to my knowledge.
Okay. With respect to, did you do anything with respect to a 911 call, if you remember?
I don't object to a leading question. He just answered, also asked the answer. He just said he doesn't do anything else.
Objection sustained.
Nothing further, Judge.
Thank you. I was going to pass over for cross-examination, and we will, but I just want to be mindful that we do stop the record at, actually it would have to be a little bit before 4:30. So just be mindful of that, as by my clock, it's 3:54. Cross-examination.
Thank you. So Officer, how many of you, if you remember, were at the hospital for this interview?
Me and Detective Williams.
Is there other officers outside of the room?
I don't know.
During your interview with Mr. Pegler, actually, let me back up. Do you remember what time the your interview? Let me back that up. Do you remember what time you arrived at the hospital?
I don't recall the time, but it was day out.
Do you recall that Mr. Pegler had not seen his son prior to this interview?
You said that I do not recall.
And then we just watched the video of your body cam. There were questions that were asked. There was a whole conversation that had happened prior to,
Right.
I'm sorry, so prior to you turning on the body cam, correct?
Right.
How long was that conversation, if you can recall?
Wait, I'm sorry, you said prior to turning on the body camera?
Yes.
Prior to turning on the body camera, as far as conversation, that wasn't an actual conversation that was long enough.
Okay, so let me clarify. When you arrived at the hospital, you were able to locate Mr. Pegler how?
Yes.
How?
I was, I believe, hospital staff, they directed us to the room.
So the room where Mr. Pegler was he was waiting to be able to see his son?
Yes, ma'am.
Do you recall if they had already pronounced his son dead at that point when you arrived?
No, ma'am.
So to your recollection, Mr. Pegler still believed that his son was alive?
I believe so.
Do you recall telling Mr. Pegler that after he answered your questions that he could see his son?
Yes, ma'am.
And then there was at one point, Mr. Pegler had asked you a question and about what had happened at the house, and you told him that you came straight to the hospital. You remember that?
Yes, ma'am.
But that was that a false statement or was that the truth?
That was not the truth.
You can see that Mr. Pegler was struggling to respond to some of your questions, even though they were things that a normal person should recollect, like how to spell their name, right?
Right.
Do you recall if you were the person that told Mr. Pegler that his son was deceased?
I don't recall that.
Do you recall if he was told after the interview was over?
Not by me, I don't recall.
Okay. Do you recall Mr. Pegler asking you several times to just please let him see his son?
Yes,
Do you recall Mr. Pegler saying that his family was forced out of their home and that they had to bring all of these belongings just a few weeks prior to this incident?
I can't really say I don't recall that.
So there's something in the interview where Mr. Kegler had referred to a personal situation, and you said, yeah, I understand, as if you knew what he was saying. Do you recall that?
I did say I understand a few times as far as watching the body camera, but to your question, I'm not sure
Okay.
at what point I say I understand too.
And then you were made aware that there was approximately 10 people living in that house on Penrod?
Yes, ma'am.
Hold on one second. I have no further questions.
Any redirect?
Very briefly, Judge. I'm gonna pick up right where Ms. Cattery left off with respect to the last question. She asked you were made aware 10 people lived in the house on Penrod. Do you remember that question?
Yes.
Okay. Were you made aware of how many were adults and how many were children? If you remember.
As far as what I remember, it was his sister as being the adult. And he had children and she had children as well.
Okay. Thank you. That's good.
Thank you. You may exit the courtroom. Thank you so much.
You'll.
Okay, do we have any other witnesses we can call for today?
Judge, I do have another witness that I can call, which would be the OIC, but I think now would be a good time to break for the day and come back Friday, which was scheduled. Given that it's 4 o'clock, we have to stop a little bit before 4:30, and the length of officer in charge's testimony is probably going to be longer than the time we have.
Well, we're here till to cover ground. How many remaining witnesses do you have?
Judge, he would be the last witness that I have here for today.
Again, we're prepared to go until 4:30. If you think you, I know that we won't be able to do both direct and cross today, but it's always a good idea just to try to get as much done as we can.
Okay, Judge, then I would call Officer Doug, or Detective Doug Williams.
Thank you. Could you please state your full name for the record
Douglas Williams,
and spell your first and last?
DOUGLAS, WILLIAMS.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the whole truth and nothing but the truth?
Yes, ma'am.
Thank you. Please have a seat in the witness chair. Watch your step coming up those steps. And once he's settled, you may proceed, Mr. Makepeace.
Thank you. Could you state your full name for the record?
Douglas Williams,
And what, are you employed, sir?
City of Detroit Police Department.
Are you currently assigned to a specific unit or division or precinct within the Detroit Police Department?
Homicide,
How long have you been with the homicide unit?
about 8 years.
You said 8 years?
Yes, sir.
Sorry, I didn't hear you. How long have you been with DPD total?
22 going on 23 years.
Before homicide, where were you assigned?
6th Precinct Special Operations.
Okay. You've been a police officer in law enforcement for 22 years, though?
Yes, sir.
All of it with Detroit?
Yes, sir.
All right. What is your role in this case, sir?
I am the officer in charge of this case.
What does it mean to be an officer in charge, sir?
So, going to the scene, viewing the scene, getting the paperwork together, making sure, filling out paperwork, submitting the proper paperwork to the APA's office, interviewing witnesses, and gathering evidence.
Okay, and in this case, did you go to the scene?
Yes.
And where was that located at?
On Penrod, I forget the address.
Okay, and Penrod in the city of Detroit, Wayne County?
Yes.
All right, tell me what you did when you first got to the scene.
Just viewed the scene. I walked up to the house, walked in the house.
Okay, how far in the house did you go?
I went to the back bedroom where the kids were all gathered.
Okay, and how many kids did you see?
Five for sure.
Okay. And were any of those kids, did you get the names of those children?
I did not.
Through the course of the investigation, did you get the name of those children?
Yes, sir.
All right. How were the kids acting when they were in that room?
They were fine. They were watching TV. They were asking for food.
Okay.
They were playing around.
All right. And was there, did you speak to anyone else? Let me ask you this. Did you speak to the kids?
No.
Okay. Did you speak to any adults that were at the location?
There was a female adult there.
And did you speak to her?
Very briefly.
How was she acting when you arrived?
She was upset.
How do you know she was upset? What made you say that?
Because she didn't want us in the house. She told us to get the hell out.
Did she say she told you to get the hell out? Did you actually interview her about what had occurred?
I did not. Somebody else took an interview.
Okay.
Interviewed her.
Did you do anything else at the scene?
Nope.
All right. Where did you go, if anywhere, after you left that scene?
To the hospital.
Which hospital did you go to?
It would be Beaumont Oakwood in Dearborn.
Okay. And why did you go to that location?
Because that's where the young man was transported to.
And the young man that would be the victim.
So I'm gonna object to, that jump into, that's where, the victim went to.
Wait, say again? You're gonna object to what?
To lack of foundation.
Okay, objection sustained. Mr. Wright, please can you lay down the foundation, please?
Yes. Let's go back. Why did you go to the location at Penrod?
We were informed by a unit at the scene that EMS.
So I'm gonna object to hearsay.
This goes to the effect on the listener, Judge.
Oh, I thought she was going to object to the we.
Oh.
The objection is, well, if you could make sure you confine your answers to the singular, but the objection is overruled. And duly noted for the record. Please continue, Mr. Makepeace.
Just for clarification, I objected to hearsay because he was about to say what the EMS told him.
I assumed that was the case, and your objection is noted and overruled.
Continue your answer.
I was informed that EMS took the young man to Oakwood Hospital in Dearborn.
Okay. And that's why you went to the Dearborn Hospital?
Yes.
Okay. How far away was that hospital? If you remember, or if you know.
Possibly, maybe more, 5 miles.
Okay. Do you remember what time you arrived at the hospital?
I do not.
Okay. And at the hospital, did you interview anyone? Or let's back up. Who did you go to the hospital with?
My partner, Officer Mia.
Okay. And did you participate in an interview with anyone?
Yes.
Who did you interview?
Officer Mia was my partner. We interviewed the young man over there in the white shirt and black tie.
And where is that person sitting?
Sitting across the courtroom in the chair over there.
For the record, the witness has identified the defendant, Your Honor.
The record will reflect the identification of the defendant.
Okay, and you saw the interview that was played, correct?
Yes.
And does that fairly and accurately depict the interview that you and Officer Mia had with the defendant?
Yes.
Okay, and at the time of that interview, had you learned about the status of the young man?
Yes.
What was
I'll
that?
object to all these leading questions, and I may ask the prosecutor again to let the witness testify instead of him feeding the witness the information he wants.
Judge, I'm trying to be specific. I don't believe my questions are leading. This is the officer in charge who conducted this investigation. So I can rephrase the question.
Could you please? Thank you so much. You watched that video. You were in the courtroom, is that correct?
Yes.
Did you remember asking the defendant what the deceased's name was?
I object to leading.
Judge, it's foundational. It's very simple.
Objection overruled.
Do you remember asking that question?
I'm sorry, can you repeat your question?
Do you remember asking the question what the deceased's name was?
Yes.
Okay. And the defendant gave you an answer of that it was his son, Taman, correct?
So we object to leading.
That's fine. That's fair, Judge.
Objection sustained. The
Do
answer will be stricken.
you remember the answer that the defendant gave you?
He gave Taman.
So I'm gonna object to that. If the response was stricken, then there is no follow-up question of, do you remember what was said to you?
Well, I was following up to nothing's actually stricken from the record. It's all there. We say that. But I was following up to my question of, do you remember asking what the deceased's name was? He said yes. And then I asked, my next question would have been in the record, what was his answer?
So just for the record, I believe that Your Honor has the ability and the power to strike something from the record, although it may appear in the transcript, it's still struck from the record.
Okay, well, let's focus on the issue, which is that last question going to be sustained? And it's not. The objection is going to be overruled. I'm following the train of thought from the question before the question that was sustained, the objection was sustained. And this would be an appropriate question and an appropriate answer. Can you please ask the question again so we all understand where we are?
What was the defendant's answer to your question of what was the deceased's name?
He said Taman.
Oh. And did the defendant give you the last name and date of birth?
Yes, he did.
Oh. And in the course of your investigation, moving past that, did you obtain a medical examiner's report?
Yes.
And may I approach Judge?
No, I object to lack of foundation, and I don't know why he's gonna have this witness testify about a report that he did not create, nor does he have the expert ability to testify about the content.
Judge, this is simply for establishing that the defendant's son is the person referenced in the report. It's establishing the identification of the victim in this case.
I also don't think that's the best evidence for that.
Okay, there's not going to be a stipulation as to the identity of the deceased.
Ms. Catteray and I did not speak about that, and this is the other way to do it, Judge. We didn't have that conversation prior to this case, though.
And I'm assuming that is not something that you're stipulating to, the identity of the deceased.
I can discuss with him after the exam today.
The objection is overruled. Please proceed.
Thank you. May I approach, Judge?
Yes.
I'm approaching with what's been admitted as Exhibit 1. Can you, is the victim's name listed on that report?
Yes.
What's the name?
Taman Quaid.
And is that the same name the defendant gave you when you were interviewing him?
Yes.
Thank you. I have nothing further, Judge.
Cross-examination.
Is it true that you charged this case because Mr. Pegler refused to speak to you?
Well, I'm going to object to the phrasing of that question. The detective doesn't charge cases, the prosecutor charges.
Objection sustained.
So I'm gonna ask you it this way then, is it true that you told Mr. Kegler that we would not have submitted his case for charges had he spoke to you?
I have never talked to Mr. Kegler since the time at the hospital.
Okay, I'm gonna ask you, did you say that to him? I'm not asking if you talked to him.
No, did not say it to him.
Did you say that outside of his house?
No, didn't say it outside his house.
What did you say outside of his house yesterday in regard to how this case was handled by yourself?
I asked his girlfriend/wife to take the paperwork, asked his daughter's name, she refused.
I'm not asking you what she said, so I'm asking for that to be struck.
I didn't say what she said, I said
No.
she refused.
Okay, so only one of us can talk at a time. I ask the questions, you answer them, okay? Understand, is that a yes?
Yes,
Did you make any statements yesterday then about Mr. Kegler's silence?
I'm gonna object to relevance, Judge. How does the conversation yesterday have anything to do with what the probable cause issue were you decided today?
Well, it goes to this officer's motive.
And presenting the case to the prosecutor's office?
Yes, I mean, I understand that the prosecutor's office has the power to charge, but if they're not given a warrant to sign with a request, then the charges would never come about and there would never be a decision from the prosecutor's office. So since the officer has discretion to decide whether or not he'd like to submit a case for charges, then it goes to his motive.
Objection is sustained.
Do you recall what time you arrived at the hospital?
I do not.
Is there a reason that you're unaware of where you were at any given time during a homicide investigation?
I'm sorry, what?
Is there a reason why you were unaware of the time during a homicide investigation?
Is there,
Yes.
I'm sorry, I'm not understanding your question.
So is there some reason that you should note the time while you're doing an investigation of a homicide as it's occurring, as the investigation is occurring?
So, as the homicide is occurring,
No. So while you're doing this investigation, okay, let's get this straight. When did you receive notice that there was a homicide or a suicide that you should report to?
I don't recall the time. What time we were notified?
So I'm just asking you about you, what time you were notified?
I don't recall the time I was notified.
Do you recall what you were doing when you were notified?
Yes,
What were you doing?
I was in the office working on another homicide.
When you say in the office, where's your office at?
1301 3rd.
How long did it take you to arrive at the house on Penrod?
When I left the office, probably about 15, 20 minutes.
Were you driving like it was an emergency? Were you driving fast or were you just taking your time?
I don't think I was driving.
In the vehicle you were traveling in, were you driving fast or were you just taking your time?
I don't think I was driving.
I just said that. The vehicle you were a passenger in, you were a passenger in a vehicle, correct?
Yes,
Okay, so that vehicle that you were in, was it going fast?
I don't recall the speed.
Do you recall if you were using any lights or sirens?
That we were not doing.
When you arrived, how many officers were at the home on Penrod?
I don't recall.
There were several though, do you recall that?
Yes,
And As officer in charge, you know who the first officers on the scene were, correct?
I would have, I would know, yes.
So who were those officers?
If I'm correct, that would be Officer Conti that was first on the scene, and Officer Kakish.
Is there also an officer that was it was his first day, started with a D?
I cannot tell you that.
Officer Denard, D-E-N-N-R-D, you familiar with him?
I am not.
There was also an officer, Paul Knapp, K-N-A-P-P.
Okay.
He was there prior to your arrival also, right?
Knapp was there.
So
I say Kakish, I'm sorry, it was Knapp.
I believe it's possible that it was Kakish, Denard, and Knapp.
Could be possible.
Did you collect any body camera video from Kakish?
All the body cam that was collected was given to the prosecutor.
So you can't recall specifically for Kakish?
I don't remember who all the body cams were from. I would have to go through and look at them.
Did you investigate or not investigate, but look through the links of the body camera video that you did get?
Objections to relevance.
What is the relevance?
And so the relevance is to what evidence there is in this case. Also, it goes to what happened when he arrived at the house.
Detective Williams arrived at the house?
Yes.
How does that question serve that purpose?
Well, he stated that when he came in, he spoke to a female who was very upset and told him to get the hell out.
Okay, and so the question that you have on the floor is,
Yes.
did Detective Williams, as